In 2020, Mr. Domelev was compelled by the presidency to take 169 working days of accumulated leave. The Center for Democratic Development and 8 other civil society organizations who described the move as an affront to the independence of the office, applied to the Supreme Court for a declaration that the action by the president was unconstitutional and null and void. The court also described as unconstitutional the president's appointment of an acting Auditor General, while there was a substantive Auditor General as equally unconstitutional. There is more in the following report.
These were accumulated leave days untaken by Domelev, according to the presidency. The presidency, in a letter on June 29, 2020, initially directed Daniel Domelev to embark on a 123 working day mandatory leave. According to the letter, the then Auditor General, since the appointment in 2016, had taken only 9 out of his 132 working days leave. The presidency at the time insisted that the actions of the president were grounded in law, as the Labour Act mandates all public sector workers, including the Auditor General, to take the mandatory leave for which they cannot forfeit. The presidency, in justifying the decision, cited what it described as a similar decision taken by late President Atamios, directing then Auditor General Edward Agyemang to go on an accumulated leave. This decision was rejected by Daniel Domelev, who pointed out to the president that he had no powers to take such a decision. In an interesting response, the president added 44 more days to the accumulated leave, making it 167. The Center for Democratic Development and 9 other civil society organizations, who described the move as an affront to the independence of the office, applied to the Supreme Court for a declaration that the action by the president was unconstitutional and null and void. The suit, filed in October 2020, was necessitated by failure of President Akufo-Addo to rescind the directive after several appeals. The Apex Court, after 2 years of hearing the matter, on Wednesday delivered its judgment and upheld the plea of the applicants. While the decision has been warmly received, the delay in resolving the matter timeously has been criticized. Daniel Domelev, however, says it's better late than never.
A good decision which has come at long last, and there are several people who reach out to me to say, is justice delayed, which is justice denied? But my response to them always is that I think the justices of the Supreme Court know better, so they know why this time and not earlier on. But let me say that from my point of view, it's better late than never. So from today going, I don't think that will be repeated on any constitutional body or any Auditor General. That is my happiness.
The former Auditor General, however, says is only concerned that the high office of the president is involved in such an illegality. He has thus urged the president to respect the Constitution.
But I'm equally sad that the highest office of the land, which is the presidency, is at the forefront of not respecting the Constitution of the country. I found it a bit disturbing. And even when I drew their attention, they told me that because I am not a lawyer, I don't appreciate the law. I am hoping that they will write to the Supreme Court to tell them that they have to go back for law classes, since they have upheld the position that I was pushing forward.
Asked whether he wants to seek further actions based on the judgment, Daniel Domelev answered in the negative.
What type of redress? The battle is for the Lord. The most important thing is that the Supreme Court has spoken and clarified what the situation is. And I'm happy they've done that, because many Ghanaians thought that there were some things untoward that I had done, which is the reason why the presidency said I should take the lead. So now that I think I feel vindicated, I don't think I need any redress beyond that. Many people have suggested it, and I jokingly tell them that, look, why would I take redress so to get compensation from taxpayers who did nothing to me because of a president who doesn't pay tax?
All right, so you heard that report put together by City News' Hansen Agyemang, and you also heard the former Auditor General, share his reaction to the Supreme Court judgment, which declared the president's order or instruction to him to proceed on leave as unconstitutional. Now, in the second case, the Supreme Court also struck out the law that allowed President Akufo-Addo to impose restrictions as part of the fight against the coronavirus pandemic. The government, at the height of the COVID-19 pandemic, caused the legislation of the imposition of the Restriction Act, which gave powers to the president to restrict human activities for the purpose of fighting the pandemic. Law professor and human rights advocate Kojo Appiagyei Etua, along with 8 others, dragged the government to the Supreme Court. The applicants sued the Attorney General, claiming that directives pursuant to the Act, such as the closure of schools and restriction of movements, were unconstitutional. They claimed that it unlawfully empowered the president to unilaterally suspend fundamental human rights and freedoms in the whole or a part of Ghana, excluding the special role of the Chief Justice and the Superior Court of Judicature in managing or regulating the suspension of fundamental human rights and freedoms in the whole or a part of Ghana, and excluding the role of Parliament in managing or regulating the suspension of fundamental human rights and freedoms in the whole or a part of Ghana. The Apex Court, in delivering this ruling, described the Act as null and void. So these have been the two major points of discussion in the legal sphere and generally across the country on the workings of the Supreme Court declaring two major acts or actions by the president as unconstitutional. The question is, justice delayed is it a case that justice delayed is justice denied, using the Doma level and the imposition of restriction acts, as case studies? My guest this morning, Gary Nimakumafu, who is the Director of Legal Affairs of the MPP. I also have Abraham Amaliba, Director of Legal Affairs of the NDC. I also have Dr. Kojo Asante, Director of Advocacy and Policy Engagement with the CDD. I also have Justice Abdullah, a private legal practitioner, and my usual suspect, Franklin Kujo, President Imani Africa. 3 of my guests are director. Franklin, you are not director, you are president. All right, gentlemen, you're welcome to the program.
Thank you. Thank you.
All right, it's been an interesting week filled with legal activity. The Supreme Court making huge pronouncements, declaring, should I say, important actions by the president as unconstitutional. One of the plaintiffs, one of the guys who went to court, is CDD, and Dr. Kojo Asante directs the advocacy and public engagement. He is with me on the panel today. I want to hear from him why they went to court and exactly what they went to court to see. Doc, so if you are with us, can you take us through what you went to seek in court? Whilst I tell us exactly why you went to court so that we can contextualize the whole discussion.
Thank you very much, and good morning to my fellow panelists.
Doc, if you can unmute, I think we can see you, but if you can unmute.
Can you hear me?
Yes, I can hear you now.
Okay. So, yeah, a good morning to fellow panelists, and also a good morning to Ghanaians everywhere listening to us today. Thank you for the opportunity. This case for us was a very important case because of the ramifications of the president's understanding of the Constitution in respect to his powers under the Constitution, particularly his implied powers under, I think, Article 297A. The Demlovo case for us, hit us in many different ways. We at CDD and many CSOs in the governance space have worked very tirelessly to try to, insulate the Auditor General from any type of executive control for years since the advent of this new constitution. The Auditor General has come very far, from the early days of the Fourth Republic, where you were not even getting sort of accounts, regular accounts done on time. And at some point it was restored, and incidentally, and instructively, it was Mr. Diajiman at that time who took over and began to develop this process of helping to bring the accounts to order. And since then, the Auditor General has grown, has done audits and so on, but it's still, there were many things that the Auditor General was not doing, which we felt that it was important that they up their game if we were going to protect the public purse and ensure that people were not misusing public resources. So when Demlevo took over, and if you recall, it was under a certain cloud because it was in the transition from President Mahama to the new President Akufo-Addo. And there was this suggestion that, this has been rushed, in order to create problems for President Akufo-Addo. But interestingly, Mr. Demlevo worked very well with the Akufo-Addo government. They provided a lot of resources for him to do several audits. He did one in Demlevo, through Occupy Ghana case, which made this whole idea of surcharging, empowered the Auditor General to go ahead and surcharge in cases where expenditures have been disallowed and so on. And he took this job seriously, where he was able to recover money for the state. So things were going very well. He was introducing innovations around asset declaration. If you ask anybody, it made, all of a sudden, people took asset declaration a lot more seriously because he was constantly monitoring, he was alerting people, he created a system to track that. So for us, civil society that worked in the governance space and were working with the Auditor General, these were innovations that, things we were calling for that had not been done, that were now being done. And then the Crown, what they call them, the Crown Associates, or
yes, the Crown Associates,
the matter with Mr. Osafuma came up. Yeah, came up, and that became sort of the unraveling of Mr. Demlevo, because he attached very senior officers, and there wasn't just Mr. Osafuma. There were directors at the finance ministry, and that then sort of the relationship between Mr. Demlevo and government, soured. And then these actions was taken. First of all, a lot of it was led by the board chair, which, we had raised concerns about this very early on, that, some of the powers he wanted to exercise was not granted to him, either under the Constitution or the statutes. The Auditor General's role was independent under the Constitution, and the board's, the extent of the board's oversight over what he does was limited. But there was this fight. So he was receiving the fight both from outside, and then the board chair then also advising the president, in one way or the other, to exercise certain powers. So then it culminated in first the leave, asking the Auditor General to go and leave, which for us was a direct interference with the with the work of the Auditor General, which was not sanctioned by the Constitution. And then later on, this retirement issue and all the issue about his change his date and all of that stuff. But what we argued, and right from the beginning, was that if the president thought that he had powers under the Constitution, particularly he was referring to Article 297A, to discipline all his appointees, and in this case, he had included all his appointees, everybody that he appoints, then in reality, he is suggesting that he can call the Chief Justice at any time and say, your leave days are go, you go on leave. Or he can call the chairperson of the Electoral Commission that you can go on leave. Because administrative disciplinary action can take many, many forms. Right? we were saying that the Constitution does not give you that power. You have to look at, the protections, or particularly independent government institutions, how they are insulated from this kind of control. Because if you extend the argument, if you get a president that wants to do mischief, they can just engineer these processes to completely interfere with the systems of checks and balances that the Constitution has designed. And you wake up one day, and we all seen it across many African jurisdictions where this has been utilized to very devastating effect, where you can completely destabilize the entire democratic project. So we needed to go to court to get a pronouncement, because there was exchanges between the president and a coalition of CSOs, the famous green papers back and forth. And this was, the president says, this is the ruling or the law. That's how I understand the law. I'm applying it. And the only way then you could address this was to go for constitutional interpretation. And that's why we went to court. And we made the point that when we're going to court, that this was not just an issue about defending Dom Leveau and getting justice for him, or making sure that he can do his work without interference. It was to say that we need to make it clear so that it might be the Electoral Commission, it might be the judiciary. Let's get clarity on this matter so that any president understands and appreciates that his implied powers under the Constitution does not extend to these independent governance institutions. And that's why we went to court. And of course, we asked for several reliefs. That declaration that, asking him to go on leave was unconstitutional. But also then appointing or purporting to appoint an Auditor General, because the way to appoint an Auditor General is very clearly stated out in the Constitution. A president cannot just come and push out an Auditor General, because the procedure for removing an Auditor General is also very specific. And then purport to appoint somebody as acting in his place, who is vested with the powers of an Auditor General. So the Supreme Court is very clear that those things are unconstitutional. We asked for further reliefs that were more related to actions that restrain the president, if it had been done in time, to sort of correct the violations that have been taken by the president at the time. And because that had become moot, the reliefs were not granted. But we also wanted, that's why I'm waiting for the judgment, because it's important to assert that the powers that are granted to the Auditor General under the Constitution can only be exercised by him and not anybody else. Unless he has delegated that power, you cannot just ask somebody else to do it. Because a lot of things happen in this back and forth, from the board chair, from the presidency, all of those things, where the board chair was got a private company to audit him. The only person that can audit is Parliament, is the one that is charged with undertaking an audit of the Auditor General. Anybody else that is exercising that power is exercising that illegal. So there are many things that have gone on. So for me, at this point, of course, some of it is too late, and it's important that we make the point that the Supreme Court, just like it takes some of these other political cases seriously and acts with alacrity, should take these constitutional restraint issues very, very, very important, because it sends a signal to anybody that holds the office what the framers of the Constitution intended and what we need to protect. I think one of the biggest challenges we have is that in most cases, when you sue the state, you have to almost like make the Attorney General a defendant or a respondent to the case. And in most cases, depending on where the Attorney General's focus and interest is, you will get a quick response or you get a delayed response. And in the cases this case that's taking this long, the responses from the Auditor General's office was very, very slow. And it affected, the court's ability to respond. At some point, our lawyer was saying, we have to go ahead if the Attorney General is not going to respond. But, the court tends to see and give room for the Attorney General to kind of get their hearts in order. So there have to be really rules around how these constitutional violation response, because there are rights involved. The imposition of restrictions, what do you do to people's rights that were violated after the fact? Or Domlevo's rights and so on. What do you do after? Would you just dismiss it and say it's unimportant because it's happened? I think these are areas that we have to look, because constitution building is a living thing. People have history and experiences, and if the psyche of the nation is consistent in terms of what they know is the right thing to be done, if it's not done early enough to let the person know that what they are doing is wrong, then people can think, oh well, I'll get it done, I'll get my short-term release and benefits, and then the law can take its course later. So there are still a lot of things to follow up and try to resolve even after this verdict. But we definitely welcome it.
That's great, and congrats to you and the other CSOs. But I mean, are we to understand, because many have raised concerns or have been unhappy about the delay of the case, how much time the case have had to spend in court. So do I get it from your submission that the delay is partly blamable on the sluggishness of the Attorney General in responding to the processes?
Yes. I think, for me, definitely that's an important part of the story. But I think the judiciary itself, in terms of how it exercises its discretion to schedule a case, I think is something we have to look, because for all of us, when you are applying justice, it has to be consistent. And I can cite how many cases between when we submitted ours and all the cases that have come through involving Parliament and the Chikwesi and all of those things that are being acted upon with expedition. It tells me that is not an inconsistent application of justice because of the way the processes are handled. So it is, for me, it's one of the things I'm looking forward to, because I really think that there has to be an engagement with the judiciary about these concerns. Having experienced it, it doesn't bode well for justice delivery, and we need to make sure that when we go to the court, we all are treated the same. So it's definitely an area that we are going to engage. There'll be a new Chief Justice. That is there ways in which we can sort of ensure that there is clear expectation from an applicant, anybody going forward the court, what to expect in terms of the scheduling of cases and the speed or that is is dealt with. So it's one of the areas that we're really disappointed about, because at the time that was happening, we thought that it needed to be dealt with. It's not just our case. I think Professor Sari was even the first one to go to court. He had to withdraw after a while because he thought he was not getting the kind of attention that he needed. So we need some clarity, and whether that will come through the rules of the court. There are more practitioners that you have assembled today. They can maybe speak a bit more to those issues, but we certainly would be trying to engage the judiciary and judicial service as to how we can mitigate these things, because it fuels very wrong perceptions about the judiciary, and we all want to keep the sanctity of the judiciary intact, because without that, we lose a significant conflict mediation, a conflict resolution mechanism in a democracy. If you don't have that, you are going to have chaos.
I see. Great. So let me come in studio. So Gary, I mean, you are director of legal affairs for the ruling party. I'm sure you obviously had some inside information and workings on this particular matter. I'm not sure. But how did this news come to you? Was it embarrassing that the president undertook an action or an act which is unconstitutional, knowing that the president himself is a constitutional lawyer, human rights lawyer, many years experience in the Supreme Court arguing constitutional cases, etc. Topical of Kiamon's and being to for an attorney general, which was a major constitutional law matter. And now here he is given the opportunity to lead the affairs of the state and undertaking actions that the Supreme Court is striking down as unconstitutional. Was it embarrassing to you? How did it come to you as a person who leads the legal team of the party that produced the president?
I think, good morning to you and good morning to my brother, Maleba.
Your opposite number.
And to your cherished viewers and listeners. I don't think I would describe this as embarrassing. I'd rather describe this as the growth of democracy and rule of law. We live in a country which are guided by the Constitution of the Republic. Sovereignty, they say, resides in the people of Ghana. Now, if anybody's action or inaction for some reason, you want to challenge it, you think that decision is inconsistent with the Constitution, under Article 1(2) of the Constitution, or not 2, you go to the Supreme Court. And it's very clear here, and if you permit me, I'll read it. It said, the Constitution is the supreme law of the land. Now, any other law which you believe is inconsistent with the Constitution, you go to the Supreme Court to have it struck out as consistent, null and void. Now, let's take it this way. You can't know it all. The courts are supposed to be there to ensure that it decides on matters between citizens, between the government and the citizens. The courts are the last bastion to save our democracy. Now, if for some reason you think that there is no way to turn to, then the society becomes anarchic. I'm very happy that this situation we found that the courts were unanimous in these decisions. I think there was also 7-0. Is that correct, Mr. Maleba? They were unanimous 7-0.
So the unanimous FC.
I don't know about that. No, because what I'm told is that it's a unanimous decision. The panel was 7 or even 5, unanimous.
So why are you asking me if you know?
In both cases, that is the Imposition Restrictions Act
and this one,
and also the 1. These were actions directly against the presidency or the executive. It tells you something that the courts have been applying the law in a very consistent manner, whether it's the president or the citizenry.
But, I mean, others have also raised some issues. We'll deal with that. But the timing of the decision, whether it was constitutional or not, even though it provides some guidance for the future, it had nothing directly to do with the president and the persons involved. So, for example, Domelevu is gone. I mean, he's not coming back as Auditor General. The harm, if there was any harm at all, has been done already. And there were no consequential orders given as well. And so that only provides guidance for the future. So the president has been saved more or less from an unconstitutional.
Listening to Dr. Pumpuni very well, he was very clear, and he said that their decision to go to court was not necessarily Domelevu, but that to guide future path going forward.
No, but he also said they had made representations to the president to rescind that decision, so to get Domelevu in place, so that the issue of the leave was to be withdrawn, so that Domelevu will work. If the president had listened to them, they wouldn't have gone to court.
Now, that is correct. I mean, I think that the view of the president and their views were at variance, hence the court action.
Yes.
And I don't disagree with anybody trying to go to court to vindicate his grievance in court at all, because as human beings, there will be grievance along the way. There will be disputes, and the courts are supposed to make sure that they settle all disputes in the country. You see, when it went against the president, I'm happy my brother Maleba and other people are happy. They say, well, now
the court is not working.
No, they say now there's democracy.
Oh, now there's democracy.
They say now there's democracy. You see, but when they take frivolous cases to court, and the courts rule against them, then they say, well, it's unanimous FC 7-0, whatever they call it, to try and denigrate the courts. You see, let us all understand something in this country. I think that nobody is above the law. Nobody is above the law. And the Constitution makes it very clear that if for some reason you think that your rights are being violated, you come to the courts. And the courts are there to be arbiters of justice and everything. So for me, I think it's a good path going forward. That is the way I see it. That, well, in the performance of his functions, he cannot subject to any control or direction by any other person, any other body. The court said what the president did was unconstitutional. We will live with it. When the judgment comes, we read the full judgment and appreciate the reasoning behind the judgment, and then to guide our path. I will not sit here to chastise any judge or any court because the court went one way or the other way. No, the courts are there to ensure that they serve as the last bastion. They are the last bastion in the democracy. You see, so I have a big difficulty when you go to court and you lose a case, then people get up and they challenge the court. I have a difficulty with that because if the courts are not there, where will you go? Where will you go? Because you cannot go and hold my brother's leg or hand or whatever and say, well, I want to, exert justice on him directly. The way you like it. The courts are there to make sure that they do all these things. So we must give the court the dignity that the court deserves. This is an enhancement of democracy. Whether it turns to the left or to the right, a decision has been taken. And this one is at the heart of the executive. I should tell you something. It's at the heart of the executive. So for me, I think it's rule of law that is at play now. We will live with it and to guide our path going forward.
Very well. So, Mr. Maliba, so now nobody's above the law. It's clear that if the president undertakes an action that is improper, the Supreme Court is bold enough to call him to order and to call the institutions of state to order. That should really be some good news for you, and it should give you some confidence when it comes to the judiciary and the role they play in our democracy.
Let me start by saying good morning to your viewers and listeners alike. Gary, morning.
Good morning, my brother.
Okay.
And you're looking good this morning too.
Well, I don't need to wait to come to power before I look good. And you say that when I was in opposition, I wasn't looking good. On the substantive matter, it is important to state some facts before we go into the main issue. Domilevo's appointment, together with the Siraj Boss's appointment, were some of the last appointments made by John Mahama before he left office. When they were in opposition, the MPP, they felt these appointments were meant to saddle them with MPP, NDC appointees. And so from the word go, they were prejudiced against Domilevo. Now, when Domilevo took over office, you will notice that some of his actions hit the NDC, these double salary returns. And at that time, I heard Isan Kuma say that this is one of, not even one, he said this is the best appointment made by John Mahama. But you see, Domilevo cannot continue auditing past events. So at a point, when he had finished that, he was now looking forward. He touched their senior minister. And that is where the problem started. And we need to make these matters clear. Now, they now saw him as being on the path to destroy this government. And so there were these all kinds of allegations. At a point in time, they even said that he had engaged in procurement and they had to bring in a private auditor to audit him and all those things. All in an attempt to get him out. So this government has never been comfortable with Domilevo. That must be told and told clearly. Has Domilevo benefited from this victory? I say no, because it's an empty one. It's an empty one because time is of essence. And that is where I want to encourage the Supreme Court to give preference to some of these public, interest cases that come before them. If you notice, this particular case, together with the other one, the COVID Imposition of Restitution Act, all these cases were before the Supreme Court so as to stop an unconstitutional act going on. But see the time that the Supreme Court has provided its decision or ruling or judgment. Way after the harm has been caused. Indeed, the World Health Organization declared COVID as no longer a pandemic, a global pandemic. And this one, our Supreme Court is coming out with this ruling. They came out with the ruling 2 days after the president had addressed the country to say that there were no more restrictions and that nobody is entitled to or required to have vaccination before he can travel. So the time that these judgments are coming out are what bothers a lot of Ghanaians. Because in effect, those unconstitutional acts have lived their full length. They have lived their, the unconstitutionality has gone on till the end of the life of those unconstitutionality. And I think that the questions to be asked is the judiciary biased in setting down cases? That I leave it to the people to answer. Are they biased in setting up cases to be heard? Because you heard the CDD, my good friend, Kuja Santi, make the point that some of these cases, when the judgments come after the unconstitutional act has taken place, then it gives people some perception that it is because it is the president. That is why these judgments are coming way after the unconstitutional act has taken place. So when you sit here and say that it means that the judiciary is working and that democracy is working, I say that no. It means that the judiciary will only work when the conduct of the president is no longer an issue. When the conduct of the president is no longer an issue. And so it is also clear that when cases of this nature are brought before the Supreme Court, and the Supreme Court does not act timeously, the Supreme Court itself is engaged in unconstitutionality. Let me repeat that. When an unconstitutional act is being complained of and brought to the Supreme Court, and the Supreme Court does not act timeously to stop the unconstitutional act, it has taken 2 years in this one, then the Supreme Court itself is engaged in an unconstitutionality. Because the Supreme Court itself is under the Constitution. You get the point? So, it is good that these judgments have come, but to what end? I can give you another case. If you remember Theophilus Donko, the Attorney General.
On the appointments.
When the MPP came to power, they started sacking CEOs. Indeed, in that matter, the plaintiff went to court because he wanted to stop the president from continuing to be dismissing CEOs. They sat down all this while. At a point, lawyers for the plaintiff went to court to say they want to withdraw it. We are now tired. If you are not giving us a date, we want to withdraw it. Supreme Court said that, no, it's a very important matter. We need to determine it. They came and determined when all vacancies had been filled and determined in favor of the plaintiff. But has the plaintiff enjoyed the fruits of his labor or judgment? No. So that's the criticism against the Supreme Court on these matters. And people are reading meanings into this judgment. Because some of the unconstitutional acts were done by the MPP, the fear is that the NDC would have also learnt, and if possible,
repeat the same unconstitutional act.
In fact, perfect it. Not only learnt, but perfect it.
Restrained.
But now, these judgments are rather tying the hands of the NDC if they come to power, and not the MPP. Because
but it's good for Ghana.
The MPP has gone away with it.
They've enjoyed it. And now you cannot enjoy it. But it's good for Ghana.
So, I'm just telling you how people are perceiving all these things, you know. So, it is important for the Supreme Court to deal with these perceptions that are coming out from these rulings that are doing. And I'm seeing that in the last week, cases that have been stale for a long time they are beginning to clear them. There's one that is also pending. That is the payment to salaries to presidential wives. You know, that one too is a matter that is pending. APAC and Co went to court on it. So, yes, we have seen under this administration, this is the first time that rulings are going against the government in the Supreme Court. Yes, it is good for our democracy, but it is coming at a time when the presidency or the president would have gone ahead to engage in the unconstitutional act, which has come to an end, and this judgment will not affect the unconstitutional conduct of the president. It's forward-looking, but it's not coming back.
You see,
Yes,
I have
just a few seconds so that I go to Franklin.
You see, we need to get certain thing very, very clear. Justice grinds and it grinds slowly.
Like justice delayed is also justice denied.
I agree with you entirely. But you see, we must situate everything, all the facts within a certain context. For instance, Amalo mentioned the COVID situation. We were in this country. There is no country in the world that did not impose restrictions.
Yeah, but I think that the discussion is that the president didn't go to the right
Through
channel.
the right channel, that's what we are saying.
The law, the constitution makes, makes it clear the channel to use in Article 33. I think.
We can challenge the procedure that was used.
So the procedure that is unconstitutional.
All these are the challenges.
No,
they are
the
challenges.
procedure that was used.
Yes.
That
That
was
gave it to
used.
that. But
What
we'll discuss that.
What was the result of the procedure that was used?
Oh.
But the fruit of the poison.
No.
No.
If the process is if the process is poisoned,
Yes.
then the fruit will
the
always
outcome
be
was
sweet.
not
You
desirable.
see, the president meant well. The president meant very well. I think that is one point you must make it very clear. There is no country in the world that did not impose
But they went through
restrictions.
the right channels.
That doesn't impose
That's what we are
restrictions.
saying. They went through the
You
right
see,
channels.
Well, what if because nobody filed a case in court?
But it's
What if?
Who
What
told
if?
you?
So I think there were people came up. I mean, there were discussions on
the issue about freedom of
on
movement.
using the emergency powers in Article 31.
Yeah, that you can use it.
But the president chose to use another route, and that was the concern. In fact, there's an Emergency Powers Act born out of Article 31.
But the people were in
the
court.
president still
They
used it.
were in court challenging that their freedom of movement had been restricted.
Yes. But if the
So
president...
that is the end result.
Yes, but we'll
That is
discuss...
the end result.
Yeah, we'll discuss
go
it. So,
there.
let's do it.
For me, all I'll say with the dome level matter is that this is a good path going forward to guide all of us.
I see.
I think that Malaba in their thinking, well, maybe is dreaming that maybe they will come back to power one day and start sacking people from offices. But that one is a matter that we'll deal with at another point in time. What we have now is a judgment has been delivered. It's a matter that is going to guide all of us going forward into the future. That is all.
I see. So let me speak to Franklin Kujo, president of Imani Africa. Franklin, interesting decision, major victory for civil society. It tells about the growing influence of civil society in our body politic, and that is great. Kudos to all of you. Even though you are not a plaintiff, I mean, I'm sure you would have whispered one or two things to your colleagues, and even though this was purely legal. But the concern, as raised by Amaliba, for example, is that this decision, though very good for the country and favorable for the growth of democracy, is coming at a time where the conduct of the president was no longer in issue. So the Domelevo matter, Domelevo has suffered what he would suffer. He is now on pension. There's no way of bringing him back to finish his term and all of that. Now the decision has come. Do you hold that view that the decision has come at a time really that the president's action is no longer in issue?
Well, first of all, good morning to my good friends, and kudos to my colleagues who took the matter to court. I mean, yes, a lot of water has passed under the bridge, right, in this particular issue. But for me, the most important factor is that going forward, we would not be entertaining these kinds of unconstitutional behavior again. Yes, there are issues about the delay in justice delivery, and I totally yield to the argument made by Kojo and I think Amaliba as well, that there are certain cases that demanded immediate attention. But all of that is fine. At least the Supreme Court has, for lack of a better word, redeemed itself, and in this case, at least it has served justice properly. So I'm not entirely sure that we should we should be gloating over it. Really, I agree, but frankly, it's to guide us for for future actions of the executive. I mean, I was entirely not surprised. I was not surprised entirely at all because it was just a matter of time that some of the actions of my good friend, Mr. President, whom sometimes I no longer recognize because he's changed so much, was going to at least hit the block. And so it's good for democracy, and it's good for, if you like, people that want to chart a path of what I call civilized behavior. You know, so it was a good thing that happened. And for me, it is to guide us into the future so that these actions maybe segues into the conversations about constitutional reform. You know, sometimes I don't even believe in this, sometimes putting everything through constitutional reform because somehow you've got a power to do right and wrong, right? And aside the fact that you have a gazillion number of advisors who could tell you what to do, you also need to take a little step back and say, look, is this the right thing to do? You know, so maybe for future conversations about the Constitution and the powers of the president, yeah, for constitutional law students, why not? But for me, I take the view that this was just one too many of some of the actions of Mr. President that at the point was just going to be called to order. And that was a definitive moment, and we should be pleased that it happened.
Very well. This is the Big Issue 97.3 City FM. We'll take a short break, but we're discussing the Supreme Court's decision on Daniel Domelevo. The Supreme Court has ruled that the action of the president in asking him to proceed on leave was unconstitutional. It was an affront to the independence of the office of the Auditor General, but the Supreme Court is here to provide the reasoning behind this judgment. We're all eagerly waiting to read those reasons. We'll take a short break, return, and then continue. But Justice Abdullah is my other guest who will have his take after the break. Don't go away. You're welcome back, and a very warm welcome to our TV viewers. This is a Big Issue on 97.3 City FM, obviously on City TV. We're also streaming on Facebook and YouTube at CityTube. The show is live and interactive. As always, you can join the discussion via our WhatsApp line 020-444-7033, and we'll be happy to read out your comments to the rest of the world. This morning, we're looking at a number of issues, two of them being matters pronounced on by the Supreme Court. The first is the matter of Daniel Domelevo's forced leave, which culminated in his eventual or subsequent retirement. If you recall, in 2020, the president asked Domelevo to proceed on his accumulated leave, 123 days to increase to 167 days. Indeed, after the leave, he was due for retirement, which meant that he could not continue with his work. Domelevo wrote back and said that the action of the president amounted to an interference in the office, in the work of the office of the Auditor General, which was unconstitutional. The president didn't budge, wrote back in very strong terms. Civil society organizations, led by CDD and a few others, tried to get the president to rescind his decision, but the president said his understanding of the law and all the tools of office of the Auditor General suggested to them that they were on the right path. So they went to court, and after 2 years, the Supreme Court this week ruled that indeed the action of the president in asking Domelevo to proceed on leave was unconstitutional. That's what we've been dealing with. And also, The imposition of the Restrictions Act, if you recall, that law was passed around the COVID time, which empowered the president to close down schools, churches, gatherings, etc. The Supreme Court has also ruled that it was unconstitutional for the president to have passed such a law. The question is really, things have ended. I mean, Domelevo is now in retirement. There's no way he's coming back. The COVID is also been declared no more a pandemic by the WHO. And last Sunday, the president also in his address to the nation said that COVID was no longer an issue in Ghana. Now we have that decision. Of what importance or relevance, if I should say, are these decisions to the governance of the state when the horses have already bolted? But that is a discussion. Others say that it is to give a guide for the future and all of that. That is what we are discussing. My guests today are Franklin Kojo, President of Imani Africa, Gary Dimakumafo, Director Legal Affairs of the NPP, Abraham Amaliba, Director Legal Affairs, the NDC, Dr. Kojo Asante, Director of Advocacy and Policy Engagement with the CDD, and Justice Abdullahi, a private legal practitioner. So let me speak to, so of course we'll deal with the issue of the Asin North by-election as well. We understand there's brisk activity in that area. That area has become home for all the political bigwigs of this country. They are crisscrossing that small constituency, and there's a lot of developmental projects we understand going on, road constructions, day and night, etc. The NPP also has said no, development is a continuum, so they are just doing what they were elected to do, to develop their constituency, and that's what they are doing. We'll look at that in the next segment of the show. But I go to Justice Abdullahi now, who is a private legal practitioner, and I'm sure, of course, he's no stranger to the Supreme Court. If you recall, he went to court on the matter of the Deputy Speaker of Parliament voting when he's presiding and all of that, and he had his own decision handed down him by the Supreme Court. Of course, we discussed we discussed that into detail. I mean, those times or when the decision was made. Here we are, another decision by the Supreme Court. Just to pick his views on what it is. Justice Abdullahi, I mean, welcome to the show. When I mention your name, it makes you feel like you are a justice of the Superior Court. I'm sure a lot of your colleagues get that a lot. And in fact, if we were to go to the bench, I'm sure you'll be called Justice Abdullahi. That would be interesting. But your quick thoughts on this decision and why, or if you can help us appreciate how the scheduling of cases at the Supreme Court is done, and why some cases could be acted upon quickly and why others take forever to be acted upon. And in fact, there are cases at the Supreme Court which have taken years and have not even been scheduled. What accounts for this? Why does the Supreme Court place some cases above theirs when in fact rights are in issue?
Thank you so much. Good morning to Franklin, Gary, and Amaliba, indeed, and Kojo. It's great being here with you. It's a privilege indeed to share the same platform. So going to the Supreme Court, usually you start with your typical rights, which upon being served upon service, you'd have 2 weeks to file your address, and then the other side would respond either, in fact, usually they will respond with the address, and that usually should close the matter. And then 2 weeks later, the two sides, usually if it involves the Attorney General, would have to file the memorandum of issues, which is usually typically what the parties believe are the core matters that the Supreme Court is to look at. Once that is filed, it's right for hearing. Usually, if there are no motions subsequent to these matters, the Supreme Court may either order for an examination or an address to be made either viva voce or otherwise, depending on the specific circumstances of the case. But outside of all these factors, you should be able to have judgment in less than 3 months. And indeed, if you remember, in Justice Abdullahi and Attorney General, that's what happened. We had judgment from the start to the end in less than 3 months. That's more like a record-breaking delivery of judgment and indeed adjudication of a constitutional matter in Ghana. I do not think that in a typical case you should travel beyond 6 months. In which case the delivery of judgment would be more relevant to the parties and indeed to the circumstances of the case. However, all sides are to blame, all stakeholders contribute to the delay. That is the lawyers, the Attorney General's office, if it is involved, most likely, and indeed the court itself. Sometimes the court is overwhelmed. Sometimes the panel, we just don't have enough panels because everybody is indeed overwhelmed. And so adjournments take almost forever to come back. And so it naturally affects in fact, as we've noticed with this one, sometimes they could even make a decision, and because they have to write the decision eventually, it takes additional month or two, and sometimes you are not lucky. You go to the court and the decision will not even be ready, and nobody will communicate to you. The registrar will simply tell you he doesn't have it, and because it also goes through a lot of processes. Once the judgment is written, it has to go through each of the panel members to also look at it and to affirm or reject whatever was written by a panel member. Or if each individual is writing, all of them would still have to go through it. And then it comes to the registrar to do the administrative work. The registrar would also go through it to ensure that all grammatical errors and everything else is corrected and sent back to the panel to affirm it before it eventually is released to the general public and indeed the parties. Now, what I've noticed is that in all these, the Attorney General has a bigger stake. So sometimes filing the memorandum of issues, for instance, you can go to the Attorney General's office for 100 times and they will not be ready because whoever is in charge of that particular case is either not available or probably does not agree to the issues that you have raised. And they may also not have their issues ready. And so you keep going back and forth, and eventually it takes so much time for the memorandum of issues to be filed. Now, that takes a lot of time if unlike the High Court, where, for instance, each party can simply file these issues without the consent or the involvement of the other. You file your issues. If they have another issue, they would also file it. And then the court ultimately will determine out of the issues filed, which of them they feel is relevant. And then you move forward. But with the Supreme Court, it doesn't work that way. You literally have to agree before it is filed. And if the person wants to delay you, that would be an opportunity to stretch the whole matter to whatever length he wants. And as typical as the Supreme Court is, usually, because it's a policy court, if the Attorney General makes the panel feel how important the decision is to the state and how urgent it must be for them to deliver their judgment, it does influence their working towards that particular case. And so they are more predisposed to listening to such calls from the Attorney General for them to maybe speed up the workings in the delivery of their written judgment. Indeed, that's why when the vetting of the Chief Justice nominee, the NDC side raised the issue of getting the written judgment of the Judge Kwesi case before they eventually vote on approval or disapproval. I of the opinion that they could have used a backdoor approach to achieve the same thing without necessarily having to embarrass the nominee, because of the nature and indeed the influence that they also have as a party. They could easily have done this without having to embarrass her. And I'm sure we probably would have made some progress. But of course, we all understand that there's a complete mistrust in the system between the opposition, the executive, and indeed the Supreme Court. And you can't blame anyone for that. I think the various decisions prior to last week possibly yielded to those suspicions and misconceptions between the three stakeholders involved in justice delivery in regards to this. And so, in a nutshell, this is how cases at the Supreme Court, this is how it travels. And so, the motions may contribute to the delay. If there are no motions, then the backstop really with the Supreme Court itself. If it wants to deliver justice and indeed their judgment in a record time, they can always do it depending on the specific circumstances of the case. And so I am not surprised when people blame them for the, in fact, calling on, these two judgments in particular, saying that, well, it has unduly delayed. I completely agree. It has indeed unduly delayed. It could have been better for all of us if the judgments were delivered in much earlier in time, because it would have then been more relevant for all of us. Now we are all talking about future because we know we have lost it. But imagine cases like these where that affects the continuous running of a state within a specific time. If the decision had come much earlier, it would have rather affected the existing government to rather remodel its ways of doing things, and it would have had better impact than waiting for a future government to be channeled through the same path. I do not think that the essence of going to court is to necessarily affect the future, but it's also to affect the present. And so if the present is lost out on us, then I think we would be failing, doing what we ought to be doing.
I see. Interesting positions. Interesting point to make. So the Attorney General obviously has some influence in getting the cases scheduled as fast as possible. But would that be fair, really? If the Attorney General feels that a case is not necessarily to his interest, then he's going to drag his feet. That really is not very fair. But the Supreme Court itself, for example, in the case under review, the Domelevo case, Supreme Court perhaps ought to have known that by the time the leave period runs out, Domelevo would have been on retirement. And so there was no way he was going to come back to office to do what he had to do. Couldn't they have taken notice of the fact that his retirement was imminent and that they needed to deal with this particular case expeditiously, so they would deploy all the arsenals or tools to make this happen in good time?
So that's exactly why I said that the Supreme Court is the biggest stakeholder in this whole saga. Their decisions supersede all other decisions. Indeed, they could have even placed an injunction on his removal until the matters are completely determined, which I believe would have been in favor of the Ghanaian than allowing him to stay out there until the matters are fully determined. So the Supreme Court indeed has that biggest opportunity to really have done as better, serve as better than just waiting and playing to the whims of the executive, more or less. And like as you rightly pointed out, and indeed as I said, that the Attorney General, being another stakeholder, obviously not compared to the Supreme Court, because the Supreme Court ultimately makes those decisions. But the Attorney General's influence cannot be overlooked because of the nature of it. Indeed, they work together. The biggest, for me, advantage you realize from the relationship between the Attorney General and the executive and the Supreme Court is that they tend to listen to the Attorney General. Mm-hmm. They tend to listen to the Attorney General, and they take the Attorney General's views on board in taking the decision, and that is very good for us. However, of course, I'm not saying that by virtue of that it affects the quality of the decisions they make. That would be very difficult to say that simply because they work together, necessarily the Attorney General has influence on them in the judgment that they deliver. It rather has influence on them, maybe with regards to time and other matters. And of course, the Attorney General also being the biggest, another stakeholder, unlike the plaintiff or any other party who may be coming to the Supreme Court, your views may be listened to, but may not really affect how things ultimately turn out, because the court decide on its own procedures, particularly with the Supreme Court, even though it has rules to guide it, but it decides when to follow and when not to follow, as we all listen to during the presidential election petition. And so you cannot really fault them when you think that they are not going the way it ought to go. If they do an adjournment for 3 months or 6 months, there's very little you can do. And so we all are contributing factors to the whole delay system, but I think we must make a conscious effort to ensure that the delivery of justice is time sensitive. And so unduly delaying judgment will not necessarily inure to the benefit of the Ghanaian.
Very well. Dr. Santi, good job, and I get the point about implied power, Article 297A and all of that. So now the Office of the Auditor General No, I mean, Dr. Asante, I mean, Dr. Kojo Asante. So now it's clear that the Office of the Attorney General truly independent as the Constitution wants. But how do we get the Auditor General to do things he has to do? So, for example, going on leave, he has to go on leave. How do we get him to go on leave? And going on leave is both good for the person and it's even good for the institution, so that one person doesn't stay there forever, cover his deeds, etc. How do we get him to go on leave if the president cannot do that? Do we go to court to compel him to go on leave, or the board? And if the board comes in to say you have to go on leave, wouldn't that be interpreted as interfering in the work of the Auditor General as far as his independence is concerned? How do we get him to work properly?
Because leave, thank you very much. Because leave is a right, right? You have to treat it as part of his conditions of service. And currently, Article 71 office holders, the conditions of service is determined by the emoluments regime under the Constitution, the committee that the president puts out. But if you read the emoluments reports, it doesn't cover the issue of leave and other types of entitlements around sort of administrative entitlements, right? And I think that's where the gap is, because if institutionally, so it's either you create a framework within that emoluments regime, bearing in mind that these independent constitutional bodies have a certain independence. You have to create a regime that allows for either you say, okay, a person has to take 20 days leave, and they have an obligation to take it within a certain period, and you provide that within that that report. So that gives you a framework, and that means that if the person is not doing it, then you can actually go to court to enforce mandamus or whatever to enforce the action. Because even the president who comes on Article 71 and will fall into it, his leave arrangements, it's entirely up to him. And it might not be good for our presidents to not be going on leave. Because it's important that they take breaks, regular breaks, and to be able to rejuvenate. So there are gaps in that process that deals particularly with Article 71 officers. And because, as we are saying, what we are trying to do is to ensure that these set of institutions that are set up to enforce the system of checks and balances within the Constitution, particularly to restrain executive excesses and so on, you create an insulation framework that ensures that people don't use the back door to undermine the ability to hold the executive accountable. But it does not also mean that you should not hold those individuals accountable in a way that, from a public policy, a public service point of view, is seamless, it's predictable, it's enforceable, and so on and so forth. So for me, that's where the gap is. That's how, if you want to deal with the leave issue, you deal with, so that then people don't see a vacuum and then try to then, use the back door to enter and deal with that problem.
Well, what will you say will be the implications of this decision or judgment for good governance going forward?
No, significant, because as I keep saying, this is not just about the audit service. You think about the judiciary itself. Think about the Electoral Commission, and think about any independent governance institution that's set up under the Constitution. And it has a specific job. All these institutions have specific responsibilities to check the system. So laws, if you read Republican Constitution, they are not made for good people. Right? It's to make sure that, depending on who becomes president, and the president might see a loophole and decide that maybe, I can dissolve parliament, and therefore, given whatever objectives I have, it can be very narrow, it can be very short term, I'll go and dissolve parliament. You create a constitutional crisis. You are in a problem. And if you are not able to self-correct these things, before you know, you have instability in a country. So the monitoring around the exercise of these powers and the limits and the parameters within which that has to be done, the intentions might be good, as Gary said. The intentions might be good, but it's important for the process to be respected. Because when that is not done, and to build a culture for that respect to happen, right? So that it's not that if an Auditor General, if an Electoral Commission is asserting, or a Shrine boss is asserting the authority, it is not disrespect to the president. They are doing their job. If a policeman stops a minister to stop a search or whatever, for speeding or whatever, they are not disrespecting the minister. They are doing their job. Otherwise, your sense of rule of law is completely thrown away. If we don't build that culture of constitutionalism, we cannot build a democratic state. And the dividends of democracy that we want for in terms of development, we will not get it. So I also really, for me, also the party, and sometimes when we are doing these things, it's like, oh, why are you always giving the president all this stress, and why are you always bashing the president or criticizing the president? We are doing it because every officer that we elect or appoint to act on our behalf are acting on our behalf for our welfare. And they need to understand the extent of their power so that they don't use the same powers we are giving to them to abuse us or undermine our collective public interest, right? Which is, either to preserve, the state, which is whether to fight corruption, whether to ensure value for money. These institutions represent us. So we don't want to create a situation where we elect or appoint a person, give them the powers, and they use the powers to act against us. So it's very important that we monitor these things. And as we are saying, maybe, yes, you might take a different opinion because you think, oh, I need to do this fast. Parliament is going to be a drag. They will disrupt things. So let me go this way. But in going that way, you would have gone and opened the door and then create a situation where somebody can say, the other person, the other person opened this door, therefore, it is equalization. Like, I've been seeing this thing about, but Mills did it, and so it's fine. No, we cannot keep doing these kinds of things. We need to appreciate that these rules and systems and so on are set up for our own interests. And if we feel that it would, undermine or weaken the ability for public servants to react and respond to emergencies or decisions, and so there are also processes that can be initiated to address that. So for me, as I said, I'm looking forward to the judgment because the devil is also in the detail. The logic, and then try to fix some of these loopholes that I have mentioned.
The issue about the judgment, deferred reasons, etc. I mean, 2 years before the case finally comes to a conclusion like this, why couldn't we have? I mean, of course, the judgment, many things should have come with. The reason should have come with the judgment because we waited for 2 years, such a critical matter. So now here we are, limited in our discussion because we don't know how the judges got to that conclusion, and now we have to wait for a few more days before we get this decision. By the time we get the reasons, I mean, the discussion would have lost steam and then the public loses out. I mean, on such critical matters, will it be your recommendation that the Supreme Court especially gets the decision with the reasons ready so that when they deliver it, I mean, few hours or a day or two later, we can get to the registry and get the full decision? Because 2 years, only for you to come and just tell us this is a conclusion, but the decisions will be made available in a week or two, that doesn't help public discourse, does it?
No, I completely agree. And this is not a matter that we have debated today. I think several times this issue has been raised with the Supreme Court. Justice makes a good point that, the whole Supreme Court challenge and the use of Article 2, which of course means that, you can really have a floodgates, situation, and your judges are constantly under pressure to turn around things very quickly. And it means that you have to have, judges that are prepared to write very quickly as well. So it is an issue. It's another issue that, because when there's a gap, then, people can make commentary without the benefit of the full judgment and content of or the logic of the law as is presented by the Supreme Court. And then it will lead to the judges then using, contempt powers, which is another thing that we don't want in a democracy, for to be utilized that way, because then that can also offend the principles of good governance and the rule of law. So it's not that gap is a problem for me. But the point is, I one of the things I've told my colleagues is that with the new Chief Justice, we really want to engage and understand some of these things and what the challenges are and how we can address it. Because maybe within the rules there might be ways in which we can mitigate some of these things, but certainly some of the things like the actual judgment delay can create more confusion than share more light. So certainly it's preferable that the reasoned judgment comes with the judgment on the day. But at the moment, that's not what I think. The one that came with the judgment was the Chiefs one that came yesterday, if I believe. So again, the consistency or inconsistencies of it and so on. So I think it's preferable because it does help with the commentary, and the understanding of where the judges are coming from.
Very well. So Gary, I mean, this issue about the delayed judgment, it doesn't really help. Is there a way we can expedite this, or is there a way we can get a Supreme Court that on such matters of public interest, when they make their decision, which we expect to be quick or expeditious, same should come with the reason, so we can have a comprehensive discussion on it and see how we better our institutions?
Well, judgments, most of the time, it goes through a lot of processes. I mean, sometimes it delays. It may not really be the cause of maybe the judges. For instance, maybe a judge is sick or indisposed, but it's on the panel. The case cannot progress. The case cannot progress unless that judge comes, or unless they have to reconstitute the entire panel. So, well, it will be much more desirable if a judgment comes and the full one comes with a delivery on the same test. It's much more desirable. I'll put it that way. But I think a lot more goes into the delay, And I'm not too certain about my brother saying that the AG's influence on the case has a lot of telling on how the court moves. I don't think that is a fair comment.
No, but I think that the point really he's making is that when you go to the Supreme Court, the court listens to the AG for various reasons. It doesn't mean that what the AG says is sacrosanct.
No, the court listens.
But the court listens to the AG. If the AG says, for example, that this has implication for policy or something, the court will be minded to deal with it expeditiously. I think that's the point he's making.
I don't believe so. The court listens to all parties.
Of course, the court listens to all parties. But because of the position of the person as attorney, not just this attorney general, we've had attorney generals before, yes, and we will have more. Because of the important position of the attorney general, the insight he has, the authority of state he carries, etc. I mean, it only makes sense that what he says must be listened to a bit more,
Yeah, but the point ought to be made that the court listens to all parties.
Of course.
So if you make it appear as if the court listening to the Attorney General has an overbearing influence on how the case progresses, I don't think that statement to me is fair. It's fair on the AG or fair on the court. That's the way I want to put it.
Okay.
And then lastly, I think that like Dr. Asante said, let's wait for the full judgments to come, so we can also know exactly what the court said about all even issue about leave. I've been thinking, why did Domelevo didn't want to go on leave?
But Domelevo also makes a point that many ministers, for example, I mean, have also not taken their leave, and who are equally circumstanced, he says, but he thinks his was in bad faith because he's been singled out and given this kind of treatment.
But see, leave is an entitlement.
Yes, it's a right. He decides to.
Why doesn't he want to go on leave? Why does he want to go on leave? I mean, I don't understand it.
But
and when he's traveling, he lost the office, and then he goes. He doesn't hand over to anybody. There are a lot of things that I know that I can't sit here and talk about.
No, but so far we've not seen any of those.
The point that ought me made is that if you work in the public service, you must understand that the public service, one day you will account for your stewardship. And me, I want everybody to understand this point. If you take a public officer as a minister of state, deputy minister of state, as whatever, CEO, whatever, it's a public service. One day you will account for your stewardship when you exit office. So whatever you are doing, your actions, your inactions, you must bear it in mind that you are accountable. But I don't understand why the Domelevo, and if you listen to what he was saying, it's like the language he was a bit offensive. Like he's so much bitter about what happened and all these things.
No, I think his comments. I mean, he is. Did you
listen to his response to the president that the president should write to the Supreme Court that they are wrong?
But when they told him,
but when he said when the president told him that they could pardon him because he's not a lawyer and his views, blah blah blah. So he's saying that okay, he wasn't a lawyer. The Supreme Court has affirmed his view on the matter. So you that you're a lawyer,
but his view was not written by him himself.
No, but it's a view he subscribes to.
His view was not written by he himself.
Yeah, but of course, the presidency
there were lawyers
the presidency knew that the view was not written by himself.
Yes.
Written by a lawyer. But the president went ahead to say they'll pardon him because he is not a lawyer.
Well, I think that for me, I'm always guided. I'm saying that this is the issue which has come, though belated or whatever it might be.
What do you say to the injury that he might have suffered? Now the thing is gone. I mean, does he have any remedy at all? The injury that he suffered,
When you say injury in
he was taken out of office.
Salary wise.
In fact, even his emoluments. He said his emoluments have not been paid.
No, if they've not been paid, they should pay him. If they don't been paid, they should pay him. This idea of people leaving office and because for some reason or the other, their salaries or emoluments or whatever are withheld. I don't think that is a good practice. If you do that kind of thing, when you go to opposition, they can also do the same thing, and it becomes a cycle. It becomes a cycle.
And that's what we're seeing actually. John Mahama has complained about this, and a few others have also complained because.
For me, I am saying there, and I'll say it anytime. If anybody is owed emolument or whatever it is, benefit, whatever it is, they should pay the person. It doesn't matter whether the person is party A or party B. If the person is really owed the money and is entitled, they should pay him. That's the point I'm making. I will not sit here and say because the person is a Malabar and I don't like his face, you don't pay him. I don't support those kind of views. They should pay him. If indeed is entitled to, they should pay him. That's the point I'm making.
The man himself is being shortchanged by his own administration. This assembly owes him legal fees.
Who? Gary. So Gary is speaking for himself. I don't know about that.
Look at it. But it's a matter. Well, you see, this one is below the belt.
No. It's been disallowed.
It's disallowed.
It's expunged from the records.
But it's a fact that yes, it is a fact that an assembly owes me.
Oh, really? So they should pay. It's in court.
And I've taken the assembly to court. It is a fact.
In their own government.
Oh, of course, but I mean, fees are fees. Fees are fees.
I see. I've not seen that. Which assembly is that?
Ghanese.
Oh, okay. So you did some work for them, and
there's a change of MCE. So the new MCE says that he's doing away with his services, but he's also saying that I've worked for you.
Okay.
So pay me what I have done, and now they are in court.
Okay, I see. So pay the people you owe. So that message should be broader and all encompassing.
But you see, I'm sure the Supreme Court members are hearing some of the criticisms. They are legitimate ones, and they will amend their ways. I just want them to be bold enough,
Not timorous.
Yes, not timorous.
But is it your view that they are timorous?
I see the rulings coming later in the day, which will not stop the president's unconstitutional conduct as not proper. Because all those acts were complained about the president's conduct. And you notice that there were some letters, exchanged between Domelevo and the presidency, and I'm sure the president might have supervised those writings too as well. And so, if the president's conduct is an issue, I think the Supreme Court should be bold enough to say, look, you are wrong, and then cut off the rot immediately and don't let it fester. And that's how I have said that the Supreme Court itself will be engaging in an unconstitutionality if it allows these things to travel their full length. But to also begin to think that it is coming from Nana Addo Dankwa Akufo-Addo as president is also mind-boggling. You remember in your preamble you indicated that this is a man who took part in the Attorney General, Attorney General's case. And for him to become president today, and most of these rulings are going against his stewardship, is mind-boggling, because you would have expected that he would do better. He has been in the forefront and styled himself as a human rights activist, and you don't expect that some of these mistakes will be done by him.
I see. Now let's look at, let's look, okay, let me deal with Justice briefly on this legal matter. Justice, what can happen to persons like Domelevo, or we can even expand the bracket? It's been declared unconstitutional. The harm has already been done to them. What can they do? Is it that the act is gone? Whatever has been done is okay, it's gone. You can't have any remedy. What can happen? Hello, Justice.
Sorry, can you hear me now?
Yes. So yes, I can hear you now.
Thank you. So it depends on the reliefs he sought from the court. If he sought to be reinstated, I'm sure the court would have dealt with that aspect of it.
No, Domelevo didn't go to court himself. Then I'm not sure they sought his reinforcement, because obviously he suffered some injury.
Yeah. So once
we sought to restrain the president from taking those actions.
Okay. All right.
Yeah.
So that's why it was moved.
Okay. Thank you. So if you didn't seek for reinstatement, which usually would have been allowed, or your entire entitlement and compensation paid if the circumstances of this nature happened, assuming by the time the delivery of judgment was made, you've already exhausted your constitutional right to remain in office. There would have been some entitlement, some form of compensation or damages that the court would have paid to you for not having the opportunity to serve your full term. But otherwise, typically, you would have been reinstated. So unlike the private sector, with the public, it's easier for reinstatement to be made. But if you're in a private sector, chances are that reinstatement may not be allowed. So if that's what we are looking out for. And indeed, this is part of our jurisprudence throughout history, because it's difficult to force somebody to work with another. But for the public service, it's not seen as the private sector, where you are likely to deal with the individual owner or owners of the company or an institution. And so these are the parameters that the court look at in determining whether or not you should be reinstated. But in this particular circumstances, I think if there will be anything at all, it will be just damages and some form of compensation to put him to the state that possibly would have been. And that will be there.
I see. Thanks. So this is a big issue on 97.3 City FM, also on City TV, on YouTube, on CityTube. We've just been looking at the matter of the Domelevo case. Supreme Court this week declared it unconstitutional, discussing generally what that means. Of course, doing that without the reasons of the court, which limits us a bit in the scope of our discussion. My guests have been Ibrahim Amaliba, Director of Legal Affairs of the NDC, Gary Nimakomafu, Director Legal Affairs of the NPP, Franklin Kojo, President Imani Africa, Kojo Asante, Doctor, Director Advocacy and Policy Engagement of the CDD, Justice Abdullah, you just heard, private legal practitioner. So we want to transition quickly to the imposition of Restrictions Act. I'm sure a lot of the things said generally in the Domelevo case will apply to this as well, the timing of it, etc. So we just take one round and then we move to the next issue, which is the matter of the Asinov. So let me start with you, Franklin. Working in the civil society space and all of that, I don't know how you viewed the imposition of the Restrictions Act at the time it was passed. Of course, a lot of people in the space argued that it gave the president too much powers, and if you have a bad person being president, he could take advantage of the situation and do anything he wanted because the law sort of gave him a blank check. Others said that of course, it meant he did away with the legislature generally and the Judiciary and Council of State. And of course, that was part of the pronouncement of the Supreme Court. How does this also come to you? Welcome news, as always.
Well, I mean, governments or politicians like chaos because the chaos is an opportunity to do a number of illiberal things, you know. So I wasn't entirely surprised that under the aegis of COVID, we hurriedly decided to pass, take a raft of actions, some of them economic, which were obviously not economic, as the data has proven. Then, of course, this particular one that was taken because, as it were, we needed to restrict movements of people. And it's a very it's a very difficult, should I call it, permutation to make, right? I mean, here is a country that wants to restrict the spread of a virus. At the same time, it needs to carefully balance that against the if you like, the liberties of every individual, which tells you clearly that in a democracy, before you take any action that is supposed to facilitate maybe development or, as it were, so-called maybe the guarantee the protect people, you still need to have that. You still need to have that little conversation with yourself, or probably with the law. That look, even though I'm going to take this action on behalf of the general public, would I be sidestepping certain basic rules? And if so, can I probably take them into consideration? But of course, we took the view that COVID was probably killing people more than guns. And so there was a need to quickly rein in everybody and then ensure that the restrictions were quite severe. I say it's a careful balance because at the same time, you are trying to propel an economy which was going to suffer. Don't forget, after 3 weeks of just lockdown, the so-called defenses of this economy just wobbled, right? So if I were president, by the way, I don't think I would have quickly restricted everybody because I would have done it probably in phases and then do it properly, you know. So it is welcome news, but I'm only just saying that it needs some fine tuning, fine balancing act, which we need to get, because I suspect that even the president was probably so much afraid of the virus, and so maybe he acted quite quickly to restrict everybody because people were being a bit stubborn. But that's the issue, right? In a democracy, even if you think people are stubborn and they would like to disobey rules, how you arrive at imposing those rules are pretty much important, and those ought to be discussed. So kudos again to those who led the charge. I don't think I had any. I think at the time I wasn't particularly.
You're also afraid of the COVID, so you're not focusing on the law.
Because something that you can use alcohol, you need to use alcohol to rub, but then in any case it can kill you even after rubbing it. What can I say? I don't know. It was scary, and so yes. So I'm a bit ambivalent, but you see, the reason why I'm a little bit happy also is because, you know, as a previous case, the government took advantage and decided to just railroad everybody under the bus. In this case, Dome level, and then of course anybody who was afraid of the virus. So I'm quite ambivalent, but I think it's a good call, really.
I see, Dr. Santi. I don't know how much work you would have done on this. Of course, you're not part of the plaintiffs, but I'm sure you would have had some view on the matter. People think that the president, indeed the Supreme Court thinks so, that the president should have gone under Article 31, which deals with emergency powers, but chose to do this. Of course, the NDC at the time also held a press conference addressed by the Secretary, which said that the bill appeared silent on the constitutional powers, on the emergency powers, and that was their concern. I don't know what you generally thought about this, and I don't know what you make of this ruling, also judgment also by the Supreme Court.
No, I was very active during the COVID period, really looking closely at our laws because, at that point we were also trying to organize an election. And there were many, many permutations that, could have led to a constitutional crisis. And I think I wrote two papers on it, looking at, some of these permutations. So I think it was just it was a lost opportunity. I mean, of course, this is in hindsight, and of course, if you are not a president and faced with a pandemic, of that magnitude, the kind of fear that was going on, I'm sure there are many different ways in which people might look at this, but I sense that the presidency took this decision because at that time we also had a very close parliament, technically some sort of a hang parliament, and wasn't, didn't want to go through the.
No, I think this was before the election that birthed the hang parliament. This was.
Oh, okay.
Yes, this was
okay.
before. Yes, that election was the 2020 election.
Yeah. Yes, but I thought that there was a sense that you don't see what 31 does for you. What 31 does for you is to make sure that even though you are in emergency, the protection of rights, are secured, so that there is a proper check, both from Parliament and judiciary on the executive, because everybody understands. In an emergency, in a way, you are suspending or limiting rights, but you need somebody to put a check on you, right? And that's what 31 has carefully framed this. And I thought it was an opportunity to really test 31. And it's not even just 31. The Public Health Act, and some of the practitioners, if I've got it correct, also where it deals with public health emergencies and so on and so forth. There are elaborate laws around this. And I really, for me, I wanted to see this process tested and how it worked with Parliament and so on and so forth. Because, as I said, the Constitution is a living document. The only way in which we are going to know whether or not our collective aspirations and codification of our laws and all of those things in practice actually serves the purpose for which we set it up is to practice it. So the sense of, at the least opportunity, you want to get out of that pathway, for me, is not helpful. So this has come again. Maybe as the judgment has come, whatever it is that sort of maybe made the president or the presidency or the executive think that it would not be adequate to address the problem, we can take a look at it. Because we need to elaborate those, in the constitutional framework, elaborate those things if we have to elaborate in the statute, to make sure, have a discussion and make sure that when we do get a public health emergency, we all know how to do it and do it within the law and in the spirit of the Constitution. I think that's where sometimes I feel that, we want more of our executive not to always be sort of reactive to these things, but to evolve the law. To be thinking, have they gone through experiences? They don't walk away, after the back and forth and say, well, sleeping dog. Let's learn from it and evolve the law. Because as for public health emergencies, we know that there will be more to come in the future from all the analysis that is being put out. So how do we build a more resilient legal system and structure and practice that is consistent and aligns with our, constitutional aspirations as a country?
Very well. So let me start off with you. I mean, why did you choose this route?
Well,
the Supreme Court has struck it down.
Well, you see, you are very interested in the Supreme Court struck it down.
No, it's important. I think it's similar. It's important.
It's important. It's important to balance certain things. You see, if you're a president, there are several briefings that you receive on a daily basis. And based on the briefing that you see on a daily basis and the situation around,
in an emergency,
you may decide to go left or to go right, depending on the information you have received. This is a situation whereby even we sitting outside, You see in America, in Italy, in the UK, other places around the world, China, where the thing even managed from, people were just dying. I mean, I watched television and I saw a huge truck where they were loading human beings as if they were just, yes, human beings just passed on. You see? And a president is confronted with this situation. Public health.
And this assistance with better public health system.
Exactly. And, you see this happening. What do you do? You're looking at this situation, what do you do?
So we can excuse him on the basis of that.
Sometimes, see, it is not always the law and the law and the law. Based on the briefing the president has received, and based on what he is confronted with, what do we do?
But his action must be anchored or must be within the conference.
I agree with you. I agree entirely. But I'm saying that the intention and the result, the intention and the result, what did it result into? Post the action the president took, what did it result into? Ghana was able to manage the COVID extremely well to the extent that most people didn't die in Ghana. The fatalities of death were very minimal in Ghana compared to other countries in the West Coast and even globally. So sometimes
but the situation in Africa generally was not that bad.
Yeah, well, maybe because of our own situations as well. But if in fact what happened in America and what happened in the West Europe actually happened in Ghana. Oh, my brother, all of us will have been gone. So
but I
we
think
need to
the
balance.
concern really is that there's a provision by the Constitution, the Public Health Act and all of that, which could have dealt with this in a similar fashion.
My interest is not to look back. My interest now, sitting here on this table, is to look or make a balancing act. What has happened before, what the president did, the actions he took, what was the result of what action that he took in the country, on our health system, on the people of Ghana. What happened? That is what my interest. Well, as whatever the court has ruled as unconstitutional and whatever it is, that's another matter. At the end of the day, whatever the president did, there was an effect of it. The effect was that public health was safeguarded. People were kept in the room. People were saying, look, you don't move, you wear your nose masks, we use your sanitizer and all those things. At the end of the day, the COVID was properly managed in a way that it saved the lives of the citizens of the country. That to me is my interest. That's my interest.
People who say
because
that
for instance,
they suffered economic loss as effect. Businesses were closed now. Those who ran schools, for example,
everybody,
people who lost relatives could not grieve properly. They had to be buried in a certain manner. People didn't even see their relatives. They had to be buried by the state.
These are public health matters. If you had COVID, they can't even open the body to do postmortem. Because those who are going to do the postmortem also we are endangering themselves. So you should have to look at the situation in a very peculiar nature. What were you confronted with? What was the president supposed to have done? Did he do it right? Did they have any effect on the society? That to me is my interest. Because, for instance, if they had allowed freedom of movement and association, everybody was supposed to move up and down to mingle and still spread the COVID and all. I mean, clearly, we will have been putting ourselves in a very big mess. So that is where I'm looking, my focus is. At the end of the day, COVID was properly managed under especially the President Akufo-Addo. At the end of the day, public health was safeguarded. At the end of the day, for the economy, he said that yes, we can bring the economy back, but we don't know how to bring lives back. Now, we all know what we are confronted with because of the COVID. Most people are not paying taxes. Things were being given out free electricity, free water, free, all sort of things, just to make sure that there was some
if you say those
mitigations.
things, then you open the floodgates for Amaliba.
Let him. He can't go to the town. He's sitting here with me. So you see, that's what I'm saying. That for me, my interest is doing a balancing act here. What the president did at the time, the effect of what he did on the citizenry, what we have now, and going forward. If you are confronted with this situation, how do we deal with it? But the most important thing is the effect of what those measures were supposed to have done. But to have allowed, one-ton free movement, assembly, churches to be going, and the COVID is still spreading all over the place. I think that, by now, Amanda will have been gone, and I will have been mourning him. But now we're sitting here together having a discussion because of the good policies that the president put in place to make sure that me and him will live today. Unfortunately, we lost some lives. We lost some lives, but I think by and large, you agree with me that the life we lost comparatively to what happened in the West. I mean, I think Ghana was on the low side. And considering even they having the best of health, systems, yet this COVID was ravaging very, very high over there. So I think we should praise the president. As to whether the court has said it's unconstitutional, the radar was used, I think we accept it in good faith. And then we will take the judgment, the full judgment, read it, appreciate it, and then see the direction going forward in the future. And I don't even pray that COVID will ever come back to Ghana again.
Sure.
Because
but,
this COVID...
We need to prepare. There
COVID,
are other things may come.
Yeah, this COVID and this effect on this economy and all that, and I think really we are all now suffering the pain. I'm telling you what we are going through, the pressures in families and all that. It is not easy. It is not easy at all. So somebody saying he suffered economic loss because of COVID. It is true. I agree with the person. Me too, I suffered economic loss because of COVID. All of us, one way or the other, will have gone through some, difficulty because of the COVID. So I think it's a national thing that we all have gone through. Let's see going forward how we all can deal with this matter. But I think the president did very well by imposing all those sanctions and all those
even though
restrictions.
On hindsight it was unconstitutional.
That's what I'm saying. That you see, let us not always pigeon ourselves with the law. Let's look at public health.
But the law is provided for public health.
Yes, whatever the situation.
So we could have played with
whatever the situation is. Whatever the situation is, I'm saying that you should look carefully at the briefing he might have received. You should look carefully at the effect of the COVID and the rate, the speed at which the COVID was moving. Look, we all woke up and said the COVID was in China. And then we said, China is far from here. The next 2-3 days, the COVID was in Ghana. So movement, because there's free movement of people everywhere.
Yeah.
Our airports were closed, okay, to prohibit people from entering the country. People were still using the ground to come into the country. You see, so I think that we have to look at this particular matter in a way, in a very broader way. That look, what the president did at the time, what was the effect of what they did on the citizens?
So the intention of the president and
the intention and its effect to me,
very well.
To me, are very, very that we have to look at it. And Abraham agrees with me.
The result is what
everything I've said. He has nothing more to say.
The process, as Gary is trying to say.
I disagree because procedural law is as important as substantive law. These briefings he said he got from experts, the president got from the experts, were not to make him panic. The briefings were to make him use the right procedures to deal with the pandemic. And the framers of our constitution didn't know that one day there will be something like this. And so they provided for it in Article 31. Indeed, we also have a Public Health Act which deals with some of these things. We are ruled by law, not by men. And that is what this president must be told in plain language. Because he does things which suggest that we are in a monarchy. This thing that he's talking about can only be done in a monarchy. Once we have chosen the path of a democracy and saying that our democracy is of a constitutional nature, we must play according to the rules. Look, people suffered under this act. People were imprisoned.
So someone was imprisoned?
You remember the man in Kumasi, the pastor in Kumasi?
So it means he will serve a minimum of 4 years?
They were imprisoned. Some were given fines. Some people suffered under this. So if today we are declaring it as null and void, are you going to compensate them? So I am saying that a president is the one who receives briefing and does not panic. A president is the one who receives briefing of this nature and put on his thinking cap to ensure that the right things are done. This excuse that, but we have solved the problem. As if he knew that if we had used the proper channels as prescribed by the Constitution, we wouldn't have this result. You can't say that. So it is not true that we should look at the outcome of the restrictions, but rather we should focus on, once again, why is it that our president is always erratic? Why?
Erratic?
Erratic in his conduct. These cases 2 cases just this week. Question his credentials as a human rights lawyer, as a president, and as somebody who will not panic. His friend, the health minister, said that he was confused and started buying drugs by heart. You remember? When they asked him at the parliamentary meeting, he said that he has stopped thinking. We don't want such people to be at the helm of affairs. And that is why, when you are a minister, you are a president, we provide you with all the necessities of life so that you can think properly. Now, if you don't think properly, me, who is not a minister, doesn't also think properly, are we not being led by blind people? So I disagree completely that because people were dying in China, who even brought the first COVID in Ghana? Is it not President Akufo-Addo when he went to people outside and brought some?
No, I don't know. He never.
The first person. He traveled outside to one of them and came back with one of them.
I don't have that information.
He came back with one of them.
I think this one we should draw this one.
He came back with one of them.
I
No,
don't
it's a
have
fact that Akufo-Addo came back with one of them.
No.
He said it himself.
Yeah, but well, I don't have
That's the
that.
first
I
case.
think you should draw this one.
No. The first case.
I think we should draw this one.
No. The first case. The first case of COVID in this country came back from a travel with the President Akufo-Addo.
No.
Well, I don't have that.
I think we should
I don't have that
draw this
information, Amaliba.
Check it.
Let's check it. I think we should.
So
I think we should draw this one.
I think that.
No, I think you should draw this one.
I want to draw it. I'm standing on my guns.
We'll check it.
The first case of COVID in this country came back from a travel with the president. I'm not saying the president himself, but it came back with a travel from the president. So for me, let's begin, and I want the Supreme Court to help us in this, because mostly when the president is being told to do something, and when he does something and you draw his attention to, he doesn't want to, change his mind. It is the Supreme Court that will deal with these matters. And I want the Supreme Court moving forward to be bold enough to put the stops on the president's conduct when some of these things are unconstitutional. You see, so for me, I think that those who suffered under the Imposition of Restrictions Act must be compensated. Because if today we are told...
How about the view that once it's been declared unconstitutional, it meant that the law never existed. So, I mean, we live with the consequences and move forward.
And those who
suffered,
who shouldn't have suffered.
Suffered. But the law never existed, so we move on.
Yeah, the law never existed. But that conduct of the person who passed a law which never existed affected somebody. What should we do to that person? Shouldn't he be compensated? So that's where I'm thinking that those who suffered under this law should also be compensated, because you have to rehabilitate the person, put him back also at where he was before this obnoxious law came into place.
I see. All right, Justice Abdullah, you have the final word on this. Before we move to I will take a break before we move to the matter of Asinov. So, Justice.
Yes, thank you so much. So I differ from Gary's position greatly. I did expect a lot from him as a brother. I mean, indeed, he's a brother, not just in West. And I say this because the absence, the non-usage of the legal regime at the time did not mean that we did not have options for which the president could have acted on. Indeed, we have always had the constitutional provisions under Chapter 5. That is the Article 31.
31, the Human Rights Chapter.
In fact, in the entire Chapter 5, to guide us, which could have saved lives even better, and which would have also advanced the course of our constitutional development, because Parliament would have had an oversight responsibility over the activities of the executive. And for me, that would have been the best option than the president acting solely with his cabinet, without anybody having a supervisory rule over what they did. If the president had invoked Article 31, there are a series of requirements that Article 31 one would have had to go through. 3 days of parliamentary briefing and constant renewal if there need be, for Parliament to now be aware of the circumstances and everything else, and to decide whether or not it was even necessary for us to go on. But we had, in this particular case, not only an unconstitutional conduct, but a conduct that the president was the sole determinant of, without anyone else knowing the basis for his determination. clearly that was not just unconstitutional, but that was clearly wrong in the face of everything else. And so, indeed, this goes to further the position that the Supreme Court ought to probably have acted timeously, because really allowing the president to continue perpetrating an unconstitutional conduct did not serve anyone's interest. When Parliament had all the authority, it's as if to say that without acting unconstitutionally, all of us probably would be dead. I mean, I do not understand the logic behind that kind of analysis. I think that we have had a primary constitution that served us better, that could have served us better, that if had been invoked, could have even led us to a better position than we are today. And having said that, if you go into the statistics, we haven't even done any better, as Gary alleges. We haven't done any better compared to our compatriots within the sub-region and indeed within the African region. You can check the statistics from the either the WHO or other Statistica, which published the death tolls and the incidence of COVID, and you see that indeed there are Mauritius, Somalia, and Madagascar, and all those other countries which did not take the route that we took, constitutional or otherwise, rather performed way better. So where do you come in to say that by virtue of the unconstitutional conduct of the president, today all of us are alive and we are doing better and all of that? It doesn't wash. When other countries acted lawfully, they acted lawfully, presumably, and they didn't even record the numbers we recorded. And in fact, more of their citizens are alive and doing better than we are doing, even in today's times. They are doing much better than we are doing, in fact, by all measurements. So where lies in the argument that by the unconstitutional conduct, the effect is better, when the effect is actually negative, to the negative?
I see.
I think that level of argument from Gary should completely, I think I recommend that he withdraws it, because the statistics do not support his position. And indeed, the laws do not support the position he adopts. Much as he admits that the president acted unlawfully, I think he should do better than simply giving us the effect of it, because the effect, it makes it even worse for us.
Very well. Thanks. So we'll move to the next topic, but before that, I'll take a short break. We've looked at the matter of the Supreme Court this week. Two major decisions from the Supreme Court, both related to the president being declared unconstitutional, demo levels leave, and then the Imposition of Restrictions Act. We've discussed that. Now we want to do mainstream politics. Asin North has been declared a vacant seat, and by-election has been announced for 27th June. The MPP is almost getting a candidate. I'm sure by close of week they'll get a candidate. NDC has a candidate already, J.T. Kwesin. The candidate disqualified is a person coming again. Why will he be the same person again? Of course, legally, for now, he is very eligible. But what are the political risks of doing so? Amaliba has been on record by saying that it's a political risk that they are taking, and they are happy about that. We'll look at all of that and see what the chances of the party will be in that election. We hear a lot of activity, developmental projects are ongoing in that constituency, but it remains a swing seat. NDC has won it about 3 times, NCP won it once, MPP won it 4 times. Indeed, J.T. Kwesin took the seat from an NDC person, Abna Durwa, and even in that 2020 election, President Akufo-Addo won the presidential. We will come back and look at what the chances are. This is the real test of the popularity or otherwise of the government, and not Kumawu. We'll be right back.
This is the neighborhood I'm having my twins.
The very reason why I took it for us. See, the price is very good and it's spacious to contain all of us.
Alphabet City. Now I'm a landlord. I don't pay rent. And my Airbnb business is booming.
To be Pamini, bank and I'm say Alphabet City. The pension pay me 20%. The payment plan, I want to share just say, very smooth.
This is a healthy place to raise our families and creating peace. Come on, be my neighbor.
Alphabet City, the ABC of home sweet home.
Alphabet City is a classy and peaceful gated community in Sakumono. We have 24/7 top-notch security and high-quality access roads. We have 3 bedrooms and 2 washrooms, 3 bedrooms and 3 washrooms with boys' quarters. We have 3 bedrooms and 4 washrooms. We have 2 bedrooms and 2 washrooms, all with beautiful kitchens and kitchenettes. Call Alphabet City on 0240-111119 or 05044999999. Alphabet City, the ABC of Home Sweet Home.
Every young woman in Ghana is going to be empowered enough to be the light and the heart of our society.
I am committed to ensuring that these NGOs are supporting government efforts and not the opposite.
We have developed a very effective cycle of admitting and rehabilitating young women in need.
I want to be your student. I don't just want to be in the program. I want to be by your side.
Get her ready.
You're saved and you're brought here to make something of yourself. Only rule is that you stay as good girls. Our investigations still focus on organizations with a seemingly clean sheet.
You will fail. You know why? Because I never lose.
Yeah, welcome back to the big issue. We are also on 97.3 City FM. We just had a discussion on the Supreme Court, the 2 key decisions delivered this week. Both actions of the president determined, or the Supreme Court said were unconstitutional. Now we want to look at the Asin North constituency. This will be the second by-election we are having in this term. The first one was in Kumau, and as was expected, the NPP, whose seat it was, won in a landslide. This one is at Asin North, and the matters heralding or culminating in the by-election, the matters themselves have been very divisive. I mean, a member of parliament being declared ineligible because at the time he contested, or he filed his nomination to contest, he owed allegiance to another country, Canada, according to the High Court. And so based on that, the law is that he couldn't have run. And so the Supreme Court has said that that election did not happen, the swearing in did not happen, it was unconstitutional. And so a new election should be held to ensure that the right thing is done. Now, Jechikwesin is declared his intention to run again. NDC is solidly behind him. They said he is unopposed, which means that he is a candidate for the party as we speak. The MPP open nominations, 2 people have filed. I understand the election is on the 7th of June. They get their candidate and then they get ready for the election on the 27th. But in the meantime, we understand the 2 parties have pitched camp in the constituency. Also because it's an interesting seat. Anybody could take it. The MPP has won it 4 times. Kennedy Japan used to be there before the split and he went to Asin Central. He won it 3 times. And NCP won it for the first time in 92. NDC then won it. So Kennedy Japan came. NDC later won it. MPP took it in 2016. Jechikwesin came in 2020. And even in 2020, Nanado won by getting 16,000. JM John Dramani Mahama came in with 15,000. Jechikwesin won by 17,000 against the MPP candidate, who was the MP at the time, who garnered 14,000. So it's an interesting seat, a typical swing seat. And so who wins this one will be key. It's the NDC seat. NDC thinks that they have to get the seat back. MPP thinks that when NDC gets it back, we'll get back to the same numbers. But does it have any implication for who is more popular? NDC has been saying that the economy is tough, things are tough, Nanado is not doing well. Would this be a referendum on Nanado's presidency and how popular the party is? or how well the NDC as an opposition has been doing. That is the situation on the ground. I'll start with Dr. Pumpuni Asante.
I think you made the rebuttal of what...
okay, so when I come to, just do that in 10 seconds.
Which one?
No, I'm sure he wants to respond to just Abdullah. But I'll give you that 10 seconds to do that. So Dr. Pumpuni Asante, we've seen by-elections, and the complaint really from people and generally civil society is that we buy votes. We do a lot of things in those areas, taking advantage of incumbency to win votes. The counter-argument is that governments are elected to deliver the goods of development. And if the by-election brings the opportunity for them to get those, why not? Where do you stand on this, given the context of Kumawu and now Asin of all we hear are happening there?
Well, thank you, and apologies. I have to jump off. That's why I'm giving my 2 pence and then leaving. I think we have to come to a certain understanding that if we continue along this path, there will be consequences for this democracy. We have been studying the rising cost of politics from 2012, and I'm sure the politicians out there, they will tell you, our politics is now dominated by money. Yes, sometimes you win, sometimes you don't win, but everybody understands that if you don't have money, that is not even a starter. And the kinds of monies that, now you have to spend to win an election, parliamentary election, from when they say you have to nurture the party, the constituency, to, going for the primaries, going from a public election, it's the monies are becoming outrageous. And that's opened the party up also for all kinds of adventures and all kinds of even illicit funding. And there are studies to showcase all of this. So we have to draw the line and find a way to manage the monetization of politics. There are many ways we can do that. Now, I see for me, Kumewu and some of these by-elections, early by-elections, as a test run. And already what we are seeing, suggests that we are going to do business as usual and keep along this path. There's vote buying, there's a significant abuse of incumbency. And, whichever way you look at it, you can't tell the narrative any differently. Citizens, the government is quite good, and we decided that, in the run-up to election, now we are going to produce all the goods that we were supposed to produce in 4 years or whatever. I mean, these things you can dress it up whatever you want. It is problematic because it distorts policy in our current economic crisis. Where if you are to apply that across what number of constituencies and whatever, you are going to be in trouble because there are many things that you have to schedule for implementation, for funding purposes, and if you have to go and take money from all kinds of places in order to produce all these visible goods so that people can vote, that becomes a problem. It's a distortion, and very soon we'll be doing debt exchange and going to the IMF. So there are implications for these business cycle type of politics that we do, particularly in the run-up to election. And if we don't learn lessons from it, we are all going to pay. We're already paying for these kinds of decision-making. My solution is simple. We have to start making examples of people, and that's why I'm happy that the OSP is stepping in. But it's not only the politicians. There is a giver and there's a receiver. Examples have to be made of the receivers as well. Because that's the only way you are going to, people have to now start to calculate, whether or not when they are sharing the money, they also go and take some. You cannot justify that, we are neglected and it's election season, it's cocoa season, so which I'm going to go and take. It is an illegal act. And if we allow for that to continue, we are all going to suffer. People don't see the linkages. But it just means that more people have to go look for more money to get elected into office. When they get elected in office and they are in government, they are going to find ways to recoup all of that investment all the people that loaned them the money, all the houses that they sold and all of that, they have to find a way to get back. And remember, all the politicians, when you're in office, now you have to find money to protect your being seated in your constituency. Because as soon as the elections are over, somebody else is working to unseat you. And now you have to find money to continue to service the constituency until the next election. It's unsustainable. And if we don't have an adult conversation about it and start to take action about it, we will continue to have this, underdevelopment, unfulfilled promises that we continue to experience, and all the challenges that we continue to experience. We look to be relatively better than others, but if history would tell anybody, you would think that you are comfortable before you know you are in a very difficult situation. So for me, it's an appeal that we shouldn't take these things lightly. We shouldn't take these things as business as usual. And the quicker we bring issues of campaign financing and party financing to the fore for us to discuss and put in measures to deal with it, the better.
I see. I mean, talking about by-elections, etc., there's a view that in order to avert the so-called dissipation of resources and all of that in those times and in those constituencies, once it's obviously a party would have won the election. So in vacancies like this, we let the party appoint or get somebody to fill the space instead of doing a full-blown election. Of course, that will have implications for constitutional review, etc., but that's fine. Others have also said that why don't you have an arrangement, a constitutional review, of course, would have to take place, but let's have midterm elections so that all these matters of by-elections, etc., we push them to the midterm. I mean, so that we can always have a way of appraising governments as we move ahead. What's your view on these two?
I mean, I think if people are worried about the specter of, a by-election being converted into some sort of a national election, but in a small town or whatever it is, because that's what happens. Because it's like the only significant political activity, everybody's there, and that always leads to violence. We've seen that in several by-elections. We saw that in Ayawaso and West Wagon and places like that. I think that the conversation about the cost of elections is a much broader conversation. Nigeria have other problems, when it comes to the cost of election, because the frequency with which they are electing officers from national gubernatorial elections, state elections, assembly, it's so almost every week there's an election in Nigeria, and people have thrown out some of these party list type approaches to dealing with it. But I think it has to be in a much bigger conversation about electoral reforms, because some people have talked about a PR system, proportional representation system, the reform of our local government system. Now, even our local government election is distorted, because our local government election, if it was running where we were electing MMDCs, for instance, and as they were supposed to be done, they were done 2 years in between the presidential and the parliamentary election. That will serve as a midterm election, right, to test the pulse of the voters ahead of the national election. But now it is running almost like in the third year, the year before a national election. And that even puts so much pressure on the budget because of the sequencing, and that is because of what happened in 2015. So when we talk about big reforms like the electoral reforms, local government reforms, and constitutional reforms, we need to put all the sequencing issues together and see how we can engineer a process that is cheaper for all of us, so that we don't create the conditions for more corruption, more lack of accountability, and just a distorted policy environment where the incentives that shape political actors are just not inured to public benefit in any way.
I see.
Those are big conversation, but it has to be had together with other reform agenda.
All right. Thank you so much, Dr. Pumpuni Asante, Dr. Kojo Pumpuni Asante of the CDD, Director Policy Engagement and Advocacy. We're grateful for your time this morning. Thanks so much. He has to run off, so thank you so much for your time. So now come back to the studio. So I have Gary Nimakun, who is Director of Legal, MPP, Maliba Abraham, Director of Legal, NDC, Franklin Kujo, President, Imani Africa, and Justice Abdullah, private legal practitioner. So, Gary, of course, I know you have some response to give to Abdullah, but the substantive question is, we understand your government is working briskly day and night to get some roads and some projects fixed in that constituency so that the people can see the development projects and vote for you. That really is the truth, because is that the truth? Because we've seen videos of road constructions, caterpillars, bulldozers on roads that before the declaration announcement of the by-election were bad, etc. What do you say to that?
All right, I'll answer that question, but in a brief. My brother Abdullah said that we haven't done well with the COVID. The statistics as at 23rd of April.
Compared it to some country, that's what he did.
Well, if you compare, but let's do the home first. The statistics in Ghana as at 23rd of April 2023 is very clear here. 170,188 are people who recorded cases who have been discharged. You know, so if you say we haven't done well,
I'm not sure he said we didn't do well. He said we've not done stellar, like as we want to, because when you compare ourselves to our peers, we are generally around the same place.
I don't think so. He didn't put any statistics out there to suggest that, so I don't think so. I disagree with him. Now let's go to there's another question. In respect of Asenof, we have always been working in Asenof. It is not because of the by-election, that is why we are working in Asenof. Well, we knew that from day one, this gentleman wasn't qualified, wasn't eligible to even contest the election in the first place. So the chiefs and opinion leaders are saying off, they themselves approach the executive, put their concerns, rules and all that, and then it was done for them, and yet it's still ongoing projects. They are still ongoing, whether that has been done in a saying off. So it's not necessarily because of the declaration of by-election by the EC that preempted the executive to go in there to go and do any development work over there. It's an ongoing project. Let's not forget that governance, development projects is an ongoing process. Central government kitty, the resources are limited. So it's a portion in a way that, some goes to the north, to the south, to the east, to the west. You cannot carry the resources to just one area. So everybody deserves a fair share of the kitty. So I think what I say enough people deserve, they are getting it. So I do not think that it's because of the declaration of the by-election, that is why some works are going on there. I mean, be that it may, whatever it is, work must go on.
But how do you explain that 3 weeks ago, for example,
yes,
I mean, the major road constructions in the area had not begun. But just 2-3 days ago, bulldozers, etc., have come, just coinciding with the announcement of the by-election. How do you explain that?
Maybe it's sheer coincidence.
And same for other projects.
Maybe it's sheer coincidence. I think the Minister for Roads ought to have been here to have answered that question.
And a lot of other projects, construction of school buildings, etc. And we saw the same in Kumawu. And it was the same explanation you gave.
You see,
I don't want to share coincidence.
You see, what we must all understand is that by-elections, to some extent, I think, over the years, I mean, both MPP, NDC, whatever it is, I think create a certain awareness. Or sometimes maybe some of the works that probably may not have been, given the needed attention to also, bring to the fore. That, we've been crying for this thing for all these years, we are not getting it. Probably it's an opportunity for us to get our fair share. But as I'm saying, you cannot be able to, push resources of the state to just one area. It must be shared across the country, and it's limited resources. So if the people of Asenof are also getting something now, Why not? They deserve it. They must get it. You know, but we must understand one thing. That seat in Assin North is the seat for MPP.
As in this election?
No, it has always been a seat for NDC. You know, MPP gets it. If you look at permutation, we've got it more than NDC.
So Kennedy Japan won it 3 times.
Yes, 3 times, and then
won it once.
Yes, that is 4. That is 4. And if you look at the numbers,
we have won it 3 times.
NDC's won it 3 times. But
Yes.
NCP, you know their relationship with the NDC in 92.
Yes.
So there's 4-4, more or less.
4-4.
More or less.
But you know, if you look at you see the 2020, you give the numbers out.
Yes. Another one
won the seat
by 16,000. Jomama got 15,000.
Exactly. Why did the people over there voters get a blouse? There was a problem there. Our country had a problem with the chiefs, with the opinion leaders in the community. That's why we lost the seat. You see, hence the change in strategy. I will not sit here and put out our strategy to the media so that you will be hearing or the rest will be hearing, and then they will say, oh, now we know why they are doing this or this. But I'm telling you, if the president won the seat, why did our candidate not also win the seat? Why did it tells you that the gentleman...
So the flip side is that maybe the NDC candidate was way stronger. So Jachi Kwesin's personality would also play a role.
I believe so.
And the same Jachi Kwesin is on the ballot.
But you see, Jachi Kwesin, and I've had the opportunity to have a discussion.
Were you in that case?
I was in that case, to have a discussion, and Amaliba was in the case as well. Have a discussion, a very heartfelt discussion on the matter with my brother, a colleague director, Amaliba. And they said they are taking the political chance, even though they know the risks involved, to proceed and put him on the ballot.
What are the risks?
You see,
because without he being in the election, the criminal matter which is ongoing will still continue. So what are the risks?
You see, you have a criminal matter hanging on your neck. You don't know the outcome of that criminal matter.
But for now, he's presumed innocent.
Of course, and you are right. And for now, it is clear that he is qualified, he's eligible to stand for the elections. No doubt about that. But you have a matter hanging on your neck, which is not a civil matter; it's a criminal matter. It can go left, it can go right. Why do you want to put yourself in a situation that, in the event that it does not go well for you, it will occasion another by-election? In the event that it does not go well for you, it will occasion another by-election in the constituency. I thought that they will have just hold on for now and say, look, gentlemen, you have a case pending on your neck. We all don't know how the case will span, whether it will be in your favor or not. Hold on for this by-election for us. Continue with your matter. Let's get a different candidate to go and represent the party and put the person out there, market the person out there, so that when the person wins these by-elections, by 2024, which is just next year, your case will have maybe ended or whatever it is. If you win your case, you come back on the ticket of the NDC for that elections. But in this state of uncertainty, and then you still declare your own intention, the party say they're supporting you, and they say they're taking a political risk.
But do you fear him? Because this is a matter that he should be concerned about and not you. You should even be happy that he is the one coming. Do you fear him? Do you fear that his popularity and the sympathy, maybe votes he may get, will disturb you?
You see,
you don't even know your candidate now.
You see, I'm only being a concerned citizen. A concerned citizen. And I'm only also, looking at him.
I'm not crying more than the bereaved.
I'm not crying more than the bereaved. See, for instance, well, if he says that you are putting out there to bring him, and so you're taking the political risks, well, so be it. But I'm not saying that the party is afraid of the Kwesin's candidature. Yes, some people are saying that, he may get a sympathy vote. And now they're doing lots of propaganda in the constituency.
I mean, both sides.
No, then this side. They are saying that, Akufo-Addo removed him, and then he said that he's not a Ghanaian. And then they speak the local dialect. Somebody who is speaking, look at the black man standing there, who is speaking the local language and speaking, and he says he's a Canadian. And so they removed from parliament. All sort of propaganda is going on the ground. And they are just trying to, misinform the people over there. When, this gentleman, knew very well that at the time when he was putting himself for the elections in 2020, filing the nomination, he knew very well that he had not obtained the citizenship.
But he had renounced, and per the Canadian law, as I understand it, once renounced, that is it. It's almost automatic that you were no more a citizen. And so the intention,
now anybody who tells you that is giving you a wrong information. Under the Canadian law, even when they are giving you certificate of renunciation, it takes effect a day after. And he got it somewhere 20th of November. So 21st is when it will take effect, not on the same day. So the fact of filling the form and putting the form in an envelope and submitting the form that you want to renounce and pay the required fees and everything, you will still have to wait till the certificate is given to you before you, because you see, it can be refused. And I've maintained this point. If you are somebody who is espionage charges and whatever it is, it will be refused. If you are somebody owing taxes on obligation, it will be refused. If you don't pay the required fee, it will be refused. If you are somebody who is a minor and below 18 years, it will be refused because you have not formed the requisite intention to even to renounce. And you see, because of the COVID, they suspended interviews. But now, COVID has been declared as no longer a public health. Yes, so interviews now it has not been reinstated. So if you are in Ghana and you want to renounce and you put the form in at the Canadian embassy, they post it to Canada. They will interview you at the embassy to find out whether you form the requisite intention to renounce. So those who are saying that the fact of putting the application in, it means you have renounced, they don't even understand what they are talking about. So the bottom line is that, well, my brother, I will advise you. And already I've advised you on quiet. And you said, no, you won't take that advice. So
no, it's not your place to advise him.
No, but it's my brother.
Okay.
I'm advising my brother.
But you advise him as a brother, not as director.
He's supposed to advise his people. You see, if I were in his shoes, I would have been bold enough to advise the General Secretary of the party, the National Chairman, that look, the Chairman, the General Secretary, with all respect to you and your office, I think that we have to wait. Let this guy finish his legal battles. When he's done and acquitted and discharged, we put him up for 2024. Just next year, But until this matter is over, we are taking a very serious political risk. We don't know how the case will end up.
Very well.
And I think that advice, if you give that advice, they will take that advice. But he's not profiting that advice.
Maybe you don't know what you don't know what their calculations are. You don't know what their strategy is.
He's not profiting that advice with them.
Maybe they have a strategy. Maybe they know for sure that because anybody could be charged for criminal something. Anybody. So if you want to base a lot of things on that, then we can't make any progress. So they know that the strength of their case, they will be victorious. And now you guys have to prove beyond reasonable doubt. The state has to prove beyond reasonable doubt.
I agree with you. That is a political risk that they said they are taking. You see, but that risk is very, very risky. I thought that they will have just let the guy get himself cleared of all cases, all charges. You see, and then you put him up for 2024. That anyway. But as I said, Abraham sitting here, he knows the truth.
2024, a different candidate, somebody else would have been MP, and that has its own difficulties. But the person wants it. He thinks he's the right person. The party supports him. Abraham, yes, I've read your comment that it's a political risk you're taking, etc. Why couldn't we get any other person to do this?
You see, there's good reason why the law allows somebody who is standing trial to continue to contest. There's good reason. Because if you have a mischievous Attorney General or a vindictive Attorney General, all you need to do is to charge all opposition members. I'm giving you time to smile to know that what I'm saying, there's sense in it. So there's good reason why the law allows that. Merely, putting somebody before court does not debar him from contesting. And we have looked at these charges. They just took Adamu Sakande charges and supplanted it. And we have noticed that these charges will not go anywhere. And when I say it was a calculated risk, I meant to say that it's a risk worth taking because these frivolous charges will end up in a discharge and acquittal. Or even
Are you not
there will
pre-
be
are
a
you
no-
not are you not
or
pre-
be-
are you
or
not
be-
are you
or-
are you not prejudicing the
or-
outcome of the case?
Yes,
Amalaba, hold on. Hold on.
They are, why? When you say charges are frivolous,
Are you not prejudicing the
but
outcome of the
he
matter?
can say he
They are
can share his
frivolous
views
charges.
on the charges.
They are frivolous charges. So I won't be surprised if the Attorney General withdraws this matter at the end of the day. So that's the calculation we have done.
You think the Attorney General will withdraw the charges?
Because you are charging somebody of a criminal mind, and you are saying that he did a passport and said he was a Ghanaian.
But it's not a fact that at the time he filled those passports and the EC forms, he knew he owed allegiance to another country.
No. Because he had put in an application. And then, because you have to show the criminality in his mind. Actus reus, mens rea. Must meet. It's not for you to say an act has taken place. So what? So, the prosecution must prove that
he had a guilty mind, he had a mens rea.
To do what he did. So the bar is high. It's for them to clear. And so we are not worried. And now you can now understand why I would have advised my General Secretary that put him up. This is a strong candidate.
With all his battles, he's strong?
He's a strong candidate. In fact, this man, when he was even
in Canada,
was assisting the communities with boreholes. So it isn't that he just came to contest. But this is somebody who was with the people already, even when he was in Canada. So it's a strong candidate for the constituency. And that's how come that immediately the Supreme Court ruled that his
name be expunged.
Not even before, it was even before. When the High Court ruled, they quickly tried to cripple him by bringing criminal charges against him, thinking that as a party, we will now abandon him and they can have a field day at the place. You saw the vigil which took place. And I'm surprised, it was only 2 days ago that I heard that he wasn't even in town, like he wasn't in the constituency.
But that could be political mobilization. So, NDC and people are able to mobilize.
If you are going to let the smaller parties go and mobilize and see.
The smaller NDC and people, I mean.
No, what I mean is that we don't have money to bash people, and you've never heard us bashing people. This is spontaneous from the constituency. If we were in power, you said, oh, you went to the neighboring communities and brought them. We don't have that money to do that. So that alone, the vigil alone will tell you that this is a strong candidate. And the hanging of the criminal charges around his neck cannot be a bar for him not to contest. And for anybody to say that because of that, he should not contest. What if at the end of the day, he's discharged and acquitted? Would we have done damage to ourselves and to him as well, or wouldn't have done? And so, I think what the MPP should be...
But you're also concerned that in case it goes the other way, it will mean that another by-election will be occasioned.
Oh yes, that's what the law says. That's what the law says.
That will cost to the state.
Yeah, that's what we pay our taxes. The money that will be used for another by-election is worth using that money than what you want and tag as a national cathedral. So the misuse of money in this administration is legendary.
I see.
But I think that clearly that's a strong candidate. They are afraid of him, you rightly indicated, because they are so worried about him. They have been going on a propaganda trail that Samu Votumana, that's also a propaganda. Are you the court? Are you the court? And when you do this and we say that you are in bed with the courts, you say, hey, why are we saying that? Because, and I think the time has come for the Supreme Court or the judiciary to also be mindful and take note of the comments of our opponent. They make so much emphatic statements. I've heard Obriboy, you bet chinetum, you bet chinetum. How? So they should also be cautious. Much as they caution us that we make comments that are disparaging of the courts, how about them? When they make such emphatic statements, it elicits some response from us. And I think that this conduct by some of their lawyers, he's not one of them, he's very circumspect, but some of their lawyers is worrying, and I think that the court should also caution them. And that's why you've seen that people are saying, you've seen social media, if a chief says you should go to court, you should go to court, when you have sold your file, it means that his brother is in the court.
I see.
So I think that the judiciary should also caution the MPP people, their lawyers, from making emphatic comments about what can happen in court. And I think that is my comment for them.
I see. Franklin, as an independent observer, I mean, what are your concerns? You think that the work ongoing in the constituency, the road construction, etc. Indeed, is that all governments are voted to do? If the people want development, a government per its calendar is now bringing development there, should we be worried about it? And I want your view also on the candidature of Jechi Kwesi.
Well, it looks to me, the videos I've seen are very interesting and funny at the same time. But there was one I saw, I think, on Yoruba TV, where the constituents are actually putting at the contractors, essentially saying, go away, go away, away. That should be indicative enough that the candidature of Mr. Kwesi is actually good for development. Because what it means essentially is because it's been put up, development is actually coming, so how much more when it's voted for as an MP? I mean, the mere mention of his name sends shivers down the spine of his opponent to the extent that they could carry development. So it presupposes that he's actually the candidate for development. So I'm not surprised he's put up the motto justice and development, or justice mostly meaning the first issue concerning his, the case he had. So I still think it's a strong candidate. I mean, just looking at the optics of what has happened over the last couple of days. But if we are going to talk about possible inducements of voters, we will never end this conversation today. But just for me, what I realized was that the mere idea that the guy is coming back again actually has elicited all these responses. And indeed, it's true, as my good friend, the MPP man, Gary. It is true that development is a continuum. We know that. But when overnight you wake up and behind your house, you realize that
there's a bulldozer.
There's a bulldozer. You definitely have to ask yourself, was there any announcement? Was there any advertisement to say that, look, today we are beginning work and what have you? Not quite. So I think Kwesi is good for development, and indeed it's true that the NDC took a huge calculated risk. I mean, otherwise, which other candidate would they really be putting up anyway? They want to make a statement that they were callously denied at the first instance, and they probably want to redeem themselves. So I don't think it's wrong to present him again. And I do not necessarily want to say that, I mean, possible inducements of candidates is something that's going to end today. It's not going to end. In fact, it's going to increase in the next election, which is also sad because, you see, I am pretty sure that some of these developments are actually not properly budgeted for, So it comes back to the conversations about somebody in an IMF program who is acting like a spoiled child, like an Arabian prince, when it's actually, in fact, a very poor boy in my village.
I see. That's Abdullah. Eligibility. We don't really have a problem with Jechi Kwesi's eligibility because as of now, he doesn't owe any allegiance to another country as far as we know, so he's eligible. Are you concerned that the NDC is putting him up even though there are difficulties with him in terms of the fact that he's standing criminal trial, a matter which is very, should I say, divisive, and all of that may happen. The MPP or the state intending to go to push this to the very end, notwithstanding the assurances the NDC or confidence the NDC has that these charges will not stand. Are you concerned that the NDC is putting him up even though he has difficulties around the criminal matter?
I would say that I would have been disappointed if the NDC had left him at this trying moment. This is the best protection they can afford him as he's contesting any criminal charges against him. I mean, we shouldn't kid with ourselves that being a sitting MP or even a candidate of the NDC, he would have a plethora of legal services, some mostly for free. The party leadership will naturally be behind him and all of that. As to whether he'll be vindicated or not would be something that you and I cannot determine at this moment. But the support would be enough as against leaving him to walk and face these same criminal charges, possibly, if the state would still want to go after him. Because really, it's not as though his candidature or absence from the ticket would absolve him from the criminal charges that the state intends to pursue. So what best way would the party do in support of a fallen hero? I mean, to simply put him up again, contest. They have a 60% or maybe 70% chance of returning him into Parliament and possibly take control over Parliament, if need be. And so I think it's not just a calculated risk. I think it's the best option under the table. They couldn't have done anything better than this particular option, which protects they themselves as a political party and also protects the candidates as an individual. And so it's a win-win situation for the NDC. And it's probably the biggest losses to the NDC, to the MPP, because his candidature naturally overrides any other person who would probably come from the MPP side of the ticket. And so, particularly if you judge from the previous elections and his numbers, now he has additional sympathy votes coming in his support. And I do not think that alleged development going on can really upset his ultimate victory. I doubt it. I mean, if you check the numbers, even between the president and he himself, I mean, the numbers are too, I mean, the gap is too wide to think that the development could change it. Maybe there could be some amount of reduction in the votes, I mean, or increase in the vote of the MPP ticket, but not to upset his eventual victory. I have my serious doubt about it. And I think it's the best decision the NDC possibly took for their own interest and indeed for the interest of Judge Grayson.
I see. So thanks so much, Justice. Well, so we'll conclude the program, but I can't conclude without saying that City TV is 5 years. We are celebrating our 5 years.
Oh, already?
On the road. Say 5 years on the road. And we thank our viewers, we thank the community, we thank you, our viewers, and everybody for being part of this journey. I don't know if I'm to pick a few seconds of well wishes from you guys.
I think congratulations will be, because City TV started in Adabraka, and alongside, I know we were appearing on the show.
Yes.
Breakfast, analysis and all that, and then the Saturday big issue. I think you've done well, and I congratulate the management, the staff, and even the guests who have been appearing on your show to sustain the content of your program. And I wish you well going into the future. You keep it up. And keep the fire blazing.
Thank you. Amaliba.
I have always known that your media house was incomplete without a TV station. And so when you added a TV station, I said, yes, I've always thought about it. And you've done extremely well. You have a different style of, approaching the news. Sometimes you do the news in communities, and then that for me is an angle that I think I want to commend you for. But 5 years, so soon it has come. I didn't know that. And now you find yourself in a very splash building. That for me is a plus too.
And I'm sure coming from the NDC and having a revolutionary route, it'd be interesting to know that the real day is June 4. So the real birthday is June 4. It's tomorrow, June 4. All right, Justice Abdullah, just a brief one from you as well.
Yeah, thank you. So, interestingly, I share the same birthday with City TV.
Oh, so you are a revolutionary baby. I see.
Yes, so that would be a very good collaboration. And I'm happy that I was part of the early morning show guest when the station started, the TV.
Yes.
I think for about a year plus, I was constantly on the morning show to contribute my thoughts to national development through your medium. And if today I'm here to almost coincide with the celebration of the 5th anniversary, I think I'm more proud to be associated with the beginning and indeed on the 5th anniversary, which also happens to be my birthday. So I think it's a good thing to congratulate the management, staff, and everyone else, and to also congratulate myself for being associated with you for the past 5 years. I believe that we can only do better for ourselves and indeed for our development as a nation going forward.
All right, thank you so much, and congratulations to you, and a happy birthday to you also in advance. We'll conclude the program. Let me just take a few messages that have come through. Ransford Diakoto said, which is the better option, fighting the illegal issue as an MP with all the privileges or not contesting and fighting the case as a normal citizen? I would choose the first. Hashtag the big issue. That is coming from Ransford Diakoto's tweet. Arthur Joshua says, if Kwesi's name be expunged, then his participation in selection of speaker should be annulled. You say, please educate me on this. Well, no, that. So I mean that's what it is. This one from Jojo says, is Gary saying development in Asinov and Kumewu is or was sheer coincidence? I think if this so-called sheer coincidence actually continues, electorate will now pray for the demise of MPs for development in their constituencies. Well, he said, by the way, I like your shirt. So that's the 5th anniversary of City TV, and we thank God so much for how far he's brought us. He's been God right from day one, and we hope that the next 5, 10, 15, 20 years will be better. What is important is that our commitment is to serving you, bringing you the news from the communities and everywhere, giving you 360 degrees on all stories we cover, and also open to feedback from you. And we are so happy that you've been part of this journey. Happy birthday to us, and we thank you so much also for doing all of this. This is how we conclude today's edition of The Big Issue. It's been live from our studios here at 5 Owula Hansen Link in Tesano, the City TV studios. And my guests have been Franklin Kujo, President, Imani Africa. Franklin, are you there? Franklin is a very key member of this team, and I've not mentioned him. And I've not heard from him. I was waiting for you. You could go to the Supreme Court, and I'm sure I would have been found guilty. I beg you.
No, I was waiting for you to fail, so that I'll send a notice to management.
I'm sorry. It was when I was mentioning the name. So quickly, I mean, your view.
Yeah, congrats.
Thank you.
Congrats. We're happy to be part of the family, and great programming, and I know it's going to be much better going forward. So congratulations again.
Thank you. Franklin is stuck with us. I mean, he's been with us right from day one, every Saturday. Prior to COVID, he was always in the studio. He's our resident panel on The Big Issue, and his views on many of our programs are very prized. Thank you so much, Franklin, for all you do for us. We thank you. So Franklin Kujo, President Imani Africa, one of my guests. Gary Nimakumafu, Director Legal Affairs, NPP. Abraham Amaliba, Director Legal Affairs, NDC. Earlier you heard Kujo Asante, Director of Policy, Engagement and Advocacy of the CDD. And Justice Abdullahi, Private Legal Practitioner. Thank you guys for coming, and we are so grateful to you also for doing the listening and the viewing. My name is Selom Adunu. And catch you again next week, same time. Have a good afternoon.